got one. That's good. Today is March 22nd, 2024. The Senate Judiciary and Public Safety Committee will come to order. We do have a quorum. Members, we have, and members of the public, we have a long agenda today, as you know. The policy deadline is 5 o'clock today. We're going to get through this agenda by 5 o'clock. I'm going to let you know that there are some bills that I know people were watching that are not on today's agenda. Because we got such a crush of re-referrals late in the policy cycle calendar here to the Judiciary Committee, and because we lost about a week and a half's worth of hearing time for some community events and longer than expected floor sessions, we are going to be putting together a late bill package or two. So just because the bill is not on today's agenda doesn't mean that it's necessarily dead for the session. Now, it may be dead for the session for other reasons, but it's not because it wasn't on the agenda today. We will be revisiting or adding some bills on for next week and probably the week after that as we put everything together. So I just want to make sure you all understood that. The Commerce Committee, I know, is also meeting today at the same time. And I think there are other committees going on as well. So we may have members coming and going. This is a hybrid hearing, which means we've got some members will be joining us remotely or virtually, as well as here in person today. And candidly, I'm going to be checking in with the Commerce Committee that I also serve on remotely, just because I can't be in two physical places at once. So the pandemic has, in some ways, resulted in a new way of doing business, and that's what we're doing. Because the agenda is so long, we're going to ask testifiers to stay succinct and to the point on their issues, and we're only going to hear issues that are within the Judiciary Committee's jurisdiction. I'm going to try to keep us focused on that. Now, I know there's going to be some context will be necessary for bills so that we can understand how our judiciary provisions fit into the bigger bill. But I really want to hope that we can keep our conversations focused on the judiciary-related provisions. Some bills, of course, are entirely within our jurisdiction, and then, of course, the whole bill will be open for our conversation. For those of you who are here for the gun violence prevention initiatives, they're in the middle of the agenda. Our aim is to get to them around 11:30 or so. Anyone who is here for those, you are of course welcome to remain in the room and enjoy the Judiciary and Public Safety Committee's operations. But if you prefer to get a cup of coffee or something from the vending machines or just to walk around, you're welcome to do so. It will not be disruptive if you come and go, as long as you don't start having loud conversations in the back of the room. Then it becomes disruptive. The agenda is grouped into sections. We're going to do our best to just keep it moving along. But we may make some adjustments in the order in which bills are heard, depending on who's here, whether the chief author for the bill is present in order for us to jump right in on that bill, or if we need to wait for someone to come from another committee. We do not plan to take a formal break for lunch either. So members will we will anticipate folks will step back because we typically don't sit at the committee table here eating food. It will not be unusual for members to step into the back area to sit down and have a bite to eat. And I, for one, will have to do the same. I don't do well without food. Do I hear an amen? I kind of heard that. I got you over here. All right. So without further ado, then, let's start with the first item on the agenda, Senate File 5026, Senator Rarick, on the predatory offender system data collection. So, Senator Rarick, appreciate your being here. Let me just make sure we This is the first committee. And there is an A1 amendment, which we will treat as an author's amendment. So Senator Limmer moves adoption of the A1 author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. Senator Rarick, would you take a few minutes and describe the bill to us?
Yeah, thank you, Mr. Chair. And members, the amendment that you just adopted removed the data provisions of the bill, which unfortunately we would have loved to have kept in it, but there was a fiscal cost, which we know cannot be covered right now. So we're taking that out, but the rest of the bill is making some important first steps. Included in those first steps, number one, we'd be removing false imprisonment crimes from the list of people who would be required to register. Number two, we would limit the extension of a person's time on the registry to only those offenses that require registration. So unrelated crimes would not extend their time on the registry. Number three would extend the time for a juvenile to complete treatment. And number four closes a loophole that requires registration for possession of child sexual abuse material and dissemination. This stems from a Supreme Court ruling and clarifies that language that either or would be required to be on the list. With that, Mr. Chair, I will turn it over to my testifiers.
Thank you, Senator Rarick. Who would you like to have go first? Ms. Bettison?
Ms. Bettison, yep.
All right. Why don't you go ahead and introduce yourself for the record and give us your testimony, please.
Good morning, Mr. Chair, members of the committee. My name is Stacy Bettison. I am a attorney. I am a part-time employed with the Minnesota Board of Public Defense as a part-time public defender, and I'm also in private practice. I'm here on behalf of Minnesota Association for Criminal Defense Lawyers, and I'm here as a former co-chair of the Predatory Offender Registry Working Group that convened for several months and put together a 200-plus page report on recommendations for improving the registry and the legislation around it so that we are making sure this registry is working as originally intended. I will keep my remarks brief, and I welcome any technical questions you have about Senator Rarick's bill. What was the purpose of the registry back in 1991 when it was enacted and enabled? It was to help law enforcement find people across the state to solve a crime. And this is outgrowth of Patty Wetterling's and the Wetterling family's horrible tragedy when Jacob went missing. There was a patchwork of law enforcement activity in terms of trying to find where would this person be that kidnapped Jacob. It has gone from originally in 1991 as a tool to assist law enforcement. Now I call it an albatross that is costing the state of Minnesota over $1 million a year to administer. And it is the net that it captures in terms of the people who are required to register has been growing over the years since 1991. And this bill is designed to refine what this legislation is intended to do. So we have two concerns about the registry generally, is the cost, and is it counterproductive to public safety by requiring so many people to register? Just a note about the provision allowing children who are part of delinquency proceedings. This provision would allow them 24 months as opposed to 6 months to complete treatment, and that would then allow a judge to determine whether the delinquency petition should be dismissed, and then the child would not be required to register. The working group has serious concerns about children being on the registry, and I just spoke with Patty Wetterling this morning to let her know that I was going to be testifying on behalf of this bill in support, and she said she believed that this bill by Senator Rarick is a good first step to getting kids off the registry. On the data, we need data to understand who is on this registry, why they're on the registry, for what crimes they're on the registry, and whether this registry actually is helping law enforcement solve crimes. We actually don't know how many crimes have been solved because of the registry. And so data, I know that has come off, but we want to stress, and MACDL wants to stress the importance of understanding this registry that we've created and that grows bigger and bigger every year and costs the state of Minnesota more money every year. On the false imprisonment, I can answer any questions about that. The bottom line is that comes off as its own offense. Right now, if someone is charged with false imprisonment, whether or not they are convicted of false imprisonment gets them on the registry as being charged with false imprisonment. And we see this come up a lot in domestic assault cases. Someone is charged with domestic assault, and they might the prosecutor might throw on a false imprisonment charge as well. The accused may plead or is found guilty of domestic assault, but because the person has been charged also with false imprisonment, they are now required to register. The working group had concerns that the crime of false imprisonment is very different than kidnapping, and it may not, and in most cases, may not involve a sex crime component at all, and so it's really unrelated, and it's capturing people that don't need to be on the registry. I welcome any of the committee members' questions, and I look forward to seeing this bill continue to move forward.
Superintendent Bueller.
Chair Latz, committee members, Senator, thank you for having us. I will be even more succinct and say that Ms. Bedison really summarized the essence of the bill, really in totality. Looking at what we're poised to do with juveniles, giving them just a little bit more of a chance, if I can say, and a little bit longer time before we decide to put them on the registry and continue that on. Along with false imprisonment, moving on to that, we currently have very few people just for false imprisonment, currently on the registry of 18,000 active registrants right now. This is going to help to move some of that off the board. As Ms. Bedison said, a lot of those false imprisonment crimes are not sex-related at all.
Thank you. I do have a question. I'm trying to, I have two questions actually. A lot of the data, or all the data provisions are deleted. What does that leave for the BCA or the Sentencing Guidelines Commission to do in terms of gathering the information that Ms. Bedison referred to that would be helpful for analysis? Ms. Bedison.
My understanding is it requires them to do zero, nothing.
Senator Rarick.
It is my understanding they'll keep operating the same way they have been. The data provisions, we're asking them to go through the registry to clean it up and get the information available to law enforcement, the provisions that Ms. Bedison spoke to make it more accessible. That's just not going to happen. So the registry will continue operating the way it has been, but we're just limiting new people going on that shouldn't be going on is what the bill is going to do at this point.
I see. Do you anticipate any future efforts to gather that data? I know, to me anyway, it's pretty important to be able to know what effect you're having with all this public taxpayer expenditure. If it's helpful, great. If it's not so helpful, we should know that too.
Yes, Mr. Chair, we will see bills come forward again next year seeking to continue down that road. We just, we were pretty sure that the $5 million fiscal note that came with it was not going to be able to be attained this year. But we wanted the provisions to move forward that are in this to start limiting the scope of what the registry is so that when we get to that part, it will be more useful. The correct people will be on the list.
I think, Senator Rarick, I think you're right. $5 million would have been awfully hard to find this year, but I hope you'll stick with it because it's important to gather that data and to analyze it. One other question I had, and I don't know if this is addressing it. It sounds like maybe it's not, but, you know, if someone is charged not only with false imprisonment, but even one of the crim sex counts, but the case is resolved in such a manner that there's a conviction for a non-registry offense. As I understand current law, they'd still have to register because of the initial charge. You're taking care of that in terms of the false imprisonment part, but how about other top-level charges that might be dismissed as part of a plea agreement? Ms. Bettison.
Chairman Latz and members of the committee, that continues to be a concern. Yes, if someone is charged with a registrable offense, but it's dismissed, or there's a plea to another offense that's not registrable, that person still does need to register because of the initial charge. What the members of the working group and Minnesota Association for Criminal Defense Lawyers' concern is that by prosecutors are able to gain a lot of leverage by charging strategically, charging registrable offenses, and that strategic charging by holding over the predatory offender registry puts the accused in a very, very difficult position. Also, a prosecutor may want to be charging and may be appropriately charging, registrable offenses, and there may be an appropriate plea that doesn't involve a registrable offense, and the prosecutor is not left with any discretion, and nor is a judge left with any discretion to let that, once that's dismissed, because they were charged, they have to register. And so prosecutors and judges are stripped of any discretion to get the defendant out of the registry requirements. And that's something we really need to work on so that we can give prosecutors and judges the discretion that they are due.
Ms. Bettison, did the task force make any recommendations in that regard, even if it's not reflected in today's bill? Chairman Latz and members of the committee, the working group did make specific recommendations on how to deal with that piece. It is in the working group's report, and I can provide certainly more information to the committee, to members of the committee on what that looks like. We do have language, proposed statutory language that would make those edits to the current registration legislation. All right. Well, I appreciate that work, and hopefully that aspect of it can be dealt with in some future piece of legislation. This is not an easy area to legislate around, and I appreciate the efforts to do this in a serious policy-oriented approach. I should ask if there's anyone else in the room that wishes to testify in connection with this bill. Not seeing anyone. Any members of the committee have any discussion or questions? Senator Kreun.
Thank you, Mr. Chair. This might be a question for council, actually. On the A1 amendment, line 1.3, it says insert Minnesota statutes 2020 before the referenced 609.2325 subdivision 1 paragraph B. I'm not familiar to seeing references like that, and I'm assuming that means that we're referring back to the 2020 statutes, but if you could just walk me through what's going on there, that'd be appreciated.
Mr. Chair and Senator Kreun, you're correct about that. 609.2325 sub 1 paragraph B was repealed, I believe, in 21. It was essentially, it had to do with vulnerable adult caregivers engaging in sexual relations with vulnerable adults. The crime was essentially moved to the criminal sexual conduct provisions. So the essence of the crime is still kind of a registrable offense, but that specific crime is no longer on the books. So the idea is to capture the crime as it existed before the repeal, so that perhaps if there's anyone out there who gets convicted of the old crime and has to register, we'd capture them, but there's no need to reference, the new crime, so to speak, because it's not there anymore.
Thank you.
Any other questions from members of the committee? Senator Carlson.
Thank you, Mr. Chair. And maybe you can just clear up a little bit of confusion I have. Is this the same predatory offender registration? Is that the same as sexual offender registration? And are there classifications like a level 2 and a level 3? And can a person appeal their classification?
Mr. Chair and Senator
Bettison.
Carlson, the predatory offender registry was initially called the sex offender registry. It was, later the name was changed to predator. And so there is no difference in the statute between sex and predator. So I hope that answers your first question.
Well, Mr. Chair, and
Senator Carlson.
I guess what I'm also wondering is does a person that goes into the registry, are they automatically put into a level 3, which requires local notification and a higher degree of monitoring than, say, perhaps a level 2? And then can the person that is put into that classification, can they appeal their classification down to, for instance, a 2?
Mr. Chair,
Ms. Bettison.
Senator Carlson, the answer is that people who go to prison for the crime are leveled, are given a level once they get out, once they're released. They are given a level 1, 2, or 3. Level 3 is the highest and requires the community notification. Whatever they're leveled at, presumably 2 or 3, they can appeal their level designation, yes. I'm not exactly familiar or close to what the timing of that is, but yes, there is an appeal mechanism to get that level down, and there's a whole process around that.
Thank you, Mr. Chair.
Senator Carlson.
So is your initial intent here is to take people out of registry, or is it to perhaps make a level change, which obviously costs a bit less for the state to monitor?
Ms. Bettison.
Mr. Chair, Senator Carlson, the intent behind the bill today is to make sure that we're requiring the right people to register, people who are actually, that there's some concern that they are actually a predator or a sex offender. That gets back to the kidnapping issues and that sort of these really high-level crimes. The false imprisonment and the other provision that we haven't really talked about, which is the restart provision. So the initial registration period for anyone who needs to register is 10 years. That 10 years can restart for another 10-year segment. So if I'm on the registry for whatever the crime is, and I am charged and go to prison for a non-registrable offense, let's just say a robbery, my registration period restarts. And so I have another 10 years from whatever the date of that incarceration is. That's another provision. We just want the restart to apply to registrable offenses, not any offense. And that would limit, that would let people, could serve their 10 years on the registry, but they're not going to be given another 10 years. So that would theoretically bring down the numbers, as well as for false imprisonment. I think the number of people on the registry for false imprisonment is a little bit under 300 people. Now, that's not a lot, but that's around 300 people that are on the registry for 10 years for false imprisonment, which really the working group sense was it's not consistent with the original intent of this legislation, which was to capture predators or people who had a history of sex offending.
Thank you.
Thank you.
Any further discussion or questions from members of the committee? Senator Rarick, I'm told this goes to the floor from here. Is that your understanding?
Yes, Mr. Chair.
Senator Pappas moves that Senate File 5026 as amended be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Rarick.
Thank you, Mr. Chair.
Senator Jasinski is next on our agenda. Is he present?
He's in the computer.
Oh, there we are.
Line, Mr. Chair.
On the big screen in front of us, Senator Jasinski.
Uh-oh.
Welcome to the Judiciary Committee. Senate File 4098 is in front of us. And I understand Scott Lambert is going to testify. If Mr. Lambert's in the room, come on down to the testifier table, please. Members, the packet's being distributed to you. Senator Jasinski, go ahead and describe your bill to us, please.
Thank you, Mr. Chair. I'll try and be quick today because I know you have a huge agenda. I apologize for not being there today. I had a commitment in my district, so I'm presenting Senate File number 4098 on behalf of consumers who lease vehicles. Driver and Vehicle Services has taken a fresh look at some old statutory language and determined they're unable to continue to provide dealerships with access to leasing information when a vehicle is turned in. This will cause a great deal of inconvenience to the customer trying to conduct an otherwise easy transaction and can cause a delay in lease transaction of at least days or weeks. This bill makes a change in the law, but doesn't actually make a change in current practice. It clarifies that a current practice of consumers and dealers can rely on and continue. This language was worked out with DVS, and there is no known opposition. As you said, Mr. Lambert is there from Minnesota Auto Dealers who can answer any questions. Thank you, Mr. Chair.
Thank you, Senator Jasinski. Mr. Lambert, do you have anything you wish to add, or are you just available to answer questions?
Mr. Chairman, Scott Lambert, President of the Minnesota Auto Dealers Association. Senator Jasinski did a nice job describing the bill. I'm happy to answer any questions you may have, or the committee may have.
All right. Members, there is a fiscal note in the packet with you. It shows a zero. The minimal costs are going to be absorbed, I understand. So pure policy bill from that standpoint. Any questions? Anyone else in the room want to testify on this? Any questions or comments from members of the committee? Senator Limmer.
Thank you, Mr. Chair. This question is for council. On the back page, page 2, there's a reference to how this summary data would be handled, and that's defined in section 13.02. And I was hoping someone could tell me how this information is governed by that chapter or that reference.
Ms. Primo.
Mr. Chair and members, under Chapter 13, summary data is non-identifying data, and agencies have general authority to provide that sort of data publicly in reports, the legislature, or other sorts of reports, but it does not identify people, and it does not include private, confidential, or other not public data.
Thank you. Thank you, Mr. Chair.
Any further questions or discussion from members of the committee? Senator Jasinski, I'm told we have the option of sending this back to the Transportation Committee where it came from, or one of the committees it came from, or maybe somewhere else. What is your preference?
Thank you, Mr. Chair. I believe it's my preference to go back to transportation to be part of an omnibus bill.
All right. Any further questions? Senator Limmer moves that Senate File 4098 be recommended to pass and be re-referred to the Transportation Committee. All those
So
in favor
moved.
say aye.
Aye.
Opposed? Motion prevails. Thank you, Senator Jasinski.
Thank you, Mr.
Thank you, Mr. Chair.
Thank you, Mr. Lambert. Next bill, Senator Wiklund, Senate File 4572. If you have any testifiers, they can come forward with you as well.
Thank you, Mr. Chair.
Senator Wiklund, this bill is coming from your committee, so why don't you go ahead and give us a description of, a brief description of the overall bill. Then I'll ask council to identify for us provisions that are specific to this committee, and then we'll take a look at the A2 amendment that's in the packet. Senator Wiklund.
Thank you, Mr. Chair. Senate File 4572 is a Department of Human Services bill, and the underlying bill, this 4572, is the Children and Family Services Policy Bill. It includes policy, technical, and housekeeping updates to statutes related to child welfare and conformity with birth records legislation enacted in 2023. As you mentioned, there is an amendment that has some additions from two other Department of Human Services policy bills that come from the Office of the Inspector General. And so I don't know if you want to have the testifier go through the Children and Family Services aspects first, and then take up the amendment and deal with the Office of the Inspector General segments, as that, because those are contained in the A2 amendment.
Senator Wiklund, you know your bill best, so we'll follow your lead on that. Should we
Okay.
have counsel identify for us those particular provisions for this committee in the first section?
Sure, that would be great.
Ms. Primo.
Mr. Chair and members, it's mostly in Article 2 and Article 4 of this bill. In Article 2, specifically Section 1, which begins at line 6.25, and then Sections 10 through 18. Section 10 begins at line 14.27, and Section 22, which begins at line 34.8, and Article 4, which begins at 38.7, and the contents of the amendment as well.
All right, Senator Wiklund, your first testifier.
Yes, and actually first, as she went through those, that reminded me that we have an amendment that it's not in your packet, but it's the A3 amendment, if that could be distributed. And that is just to remove one section, Section 11, because we found last night that it's a provision that needs more discussion, and we'd like to take it out of the bill so that work can happen.
Okay, the staff is distributing the A3 amendment. Page 16 deletes Section 11. Any questions or discussion from members of the committee on the A3 amendment? Senator Westland moves adoption of the A3 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted.
And now,
Senator Wiklund?
if I could have my testifier talk about the sections that are within the jurisdiction of this committee.
Perfect. If you go ahead and identify yourself for the record and present your testimony.
Great, thank you, Mr. Chair. Members, I'm Jennifer Sommerfeld. I'm the Legislative Director for Children and Family Services, which includes our Child Safety and Permanency Division, and the provisions I'm going to cover are from that division within our administration. My understanding is actually sections 11 through 18 that are in the jurisdiction, because it was renumbered after the last hearing. Because we amended out Section 11, I'll start at Section 12 to walk through, or Section 1, and then move on to 12. Section 1 is a provision that is necessary because we recently ran into an issue while trying to obtain information from the Predatory Offenders Registry for child protection cases. If there is a report made to a local agency of threatened sexual abuse, that agency is required to do an investigation, and part of that investigation, if the threatened sexual abuse includes potentially somebody who's in the home with a child who's on that list, getting that information. The language that is in current statute that's being amended in the bill refers to family assessments, which are not investigations. They're different. And so a recent change in how the BCA review is interpreting that, they've stopped providing that information to local agencies because, in fact, there is a difference between an investigation and an assessment. So we're simply amending that language to put in investigation so we can continue to access information for investigations.
Thank you, and I'll let you continue, but Ms. Sommerfeld, if you could identify the page in the bill that's before us when you get to that point, or someone could,
Oh, I'm
that'd be
sorry,
helpful
yes.
for us to follow.
I don't have the bill with me.
Members, we have the first engrossment in front of us.
I have to find her. Yeah, sorry about that. So that was starting on line 6.25. So moving forward to section 12, which I'm trying to find, which starts on line 19.30. So this provision simply clarifies the protection, supervision, court review requirements, and requires courts to review them to ensure that they are consistently applied. There's policy on this that governs this, but it is not necessarily always consistent across the state. So this section simply aligns statute with current practice to make sure it's consistent for all cases and across counties. Section 13, which begins on line 21.4, clarifies agency access to criminal and maltreatment history for relatives who are being considered for foster care placements, regardless of whether the relatives are licensed and must be licensed. And then when petitions are filed to transfer permanent legal and physical custody, which we also refer to as TPLPCs, to a relative. So that's it for that provision, that's it. That one is actually just clarifying existing practice again and aligning statute with what is currently done. Section 14 prohibits placement of children in an unlicensed emergency relative placement, family foster home, when the agency is aware that there is a permanent disqualification for foster care licensure. So if they're doing an emergency placement and they know somebody in the household is disqualified and would not be eligible to provide foster care for that reason, they cannot do an emergency placement there. Section 15 removes the ability to terminate a parent's rights simply because the parent is not able to financially support their child. That would unfairly burden families who live in poverty from not being able to raise their children if this were to remain and be used as the sole purpose. Section 16 clarifies that the permanency disposition of TPLPC to a parent is distinct from that of a relative. There's been some confusion in courts that mix concepts in family law for custody with what happens in transfers of custody in child protection cases. So you actually cannot do a TPLPC to a parent. You simply give them custody of their children like you would in family court. But a transfer of permanent legal and physical custody is a permanency designation for relatives who are not parents. So we are just clarifying that in statute. And then sections 17 and 18 clarify that while court review processes and work is continuing on adoptions, if there's an appeal pending for not just a guardianship order, which right now they would not move forward with the guardianship, but also if there's a termination of parental rights, we are prohibiting the court from finalizing that adoption so that the appeal can be heard. What happens is there might be an appeal waiting to be heard, and they finalize an adoption, and then at that point the appeal, which could be from a relative who wants to care for their child, is not able to move forward. And then I'll move on to Article 4 if there aren't any questions.
Are there any questions for Director Sommerfeld on what she's already covered? Not seeing any. Go ahead, Director.
Great, thank you. So Article 4, all of the sections, they really are just making sure that our laws that we have when we govern birth records in the agency comply with the law that was passed last year that provides greater access to original birth records for adult adoptees. So we implement part of that law. There were some pieces that were contradictory, so this section changes those to make sure it can be implemented. And I'll note we did work with the core advocates who were working on last year's bill to establish access to those original birth records to ensure that they were comfortable with these provisions, and I believe they've indicated that they are supportive of them. Thank you.
Any questions for Director Sommerfeld on Article 4? Not seeing any. Senator Wiklund?
Chair Latz, the next part of the bill would be what would be contained in Amendment A2 that you do have in your packet. And I can have the testifier can go through the sections that are in that amendment if you'd like.
Terrific. And that testifier will be?
Thank you, Mr. Chair. My name is Ari Didion. I'm the Acting Legislative Director for the DHS Office of Inspector General. The A2 Authors Amendment contains a few provisions from a couple of Office of Inspector General policy bills. We're just hitching a ride on our colleague and Senator Wiklund's bill here today. Section 1 of the A2 amendment relates to a proposal to make the email addresses for license and certification holders public information, and this section exempts family child foster care providers from this requirement. And then section 2 of the amendment, which begins at the top of page 5, this is a conforming change. This adds authorized agents to the list of individuals in certified license exempt childcare centers to the individuals who require a background study. The authorized agent was added to licensing statute in a previous section, but the background studies statute was not changed to align with this change, so this is just a conforming change. It does not change current practice. And then section 3, which begins on line 6.12, relates to a proposal to ensure that individuals who submit tips of fraud, waste, or abuse in the child care assistance program have their identity kept confidential after an investigation is complete if those tips are submitted in good faith. And this aligns CCAP investigatory statute and investigatory practice with how things are done in medical assistance. And I'd be happy to take any questions on the amendment.
So Director Didion, I appreciate the cross-reference to the rules of criminal procedure and understanding the courts would be handling any disclosures in accordance with those rules and following an in-camera review, which I think is an appropriate way to handle those confidentiality concerns. So thank you for including that provision. Any questions from members of the committee or discussion regarding the Office of Inspector General provisions? Anyone in the audience wish to come and testify on any provisions in this bill that are before this committee? Senator Westland moves adoption of the A2 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Any further questions or discussion relating to Senate File 4572 as amended? Senator Wiklund, is this going back to your committee for inclusion in a larger bill, or is...
I believe so. I believe that's the case because we have other policy bills from the department that didn't have, provisions that are part of this committee's jurisdiction.
Okay, so we'll send it back to you.
Okay.
All right. Senator Pappas moves that Senate File 4572 as amended be recommended to pass and be re-referred to the Senate Committee on Health and Human Services. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Wiklund.
Thank you.
No, don't go anywhere.
Nope.
We're going to take up your Senate File 4860 next on vital record provisions. And if Lisa Timjan, did I get
Lisa
that right?
Timjan.
Never had that problem my whole life.
Messed it. Yeah, I bet. All right, Senator, members, the bill has been distributed along with some background material from the Department of Health. This comes to us from the Health and Human Services Committee, and I anticipate this too will go back to HHS, Senator Wiklund?
Yes. Yes, please.
All right, why don't you go ahead and tell us what we need to know about it?
Yeah, just briefly, this is the Department of Health's policy bill that relates to vital records, and it contains 4 components that help provide clarity to the vital records process in Minnesota. And as you stated, Lisa Timjan is here to talk about the bill provisions.
Go ahead, identify your full name for the record and present your testimony.
Thank you, Mr. Chair. For the record, Lisa Timjan, and I'm Legislative Director at the Minnesota Department of Health. So this year we have a policy proposal which contains 4 components that will help provide clarity to vital records process in Minnesota. Going in order in the bill, you'll see the first is clarifying vital records definitions, including the differences between corrections, amendments, and replacements. These changes should help provide clarity both to state programs, courts, as well as any individuals trying to navigate the system. The second piece and deals with ensuring timely birth registration for all safe place infants. Current law does not address birth records and how those infants get those in a timely manner, so this just ensures that they are treated the same as all other births in Minnesota. The third provision has to do with the Minnesota's Father Adoption Registry. In Minnesota, all fathers, there needs to be a search for putative fathers as part of every adoption. Men are allowed to register with the Minnesota Fathers Adoption Registry, which can notify them if a child is in process of being adopted. By making this change and allowing men to have access to this, the fathers will be able to access the search without needing a court order or an attorney, so it makes the process a little more simple and timely, as well as cheaper. This also helps with assisting some step-parent adoptions where a father has children whose mother is deceased or has lost her parental rights, and in general will just remove delays and costs for the adoption process for parents. And then the fourth provision is simply repealing obsolete reasons for replacing a birth record, which is the subsequent marriage as basis for changing birth records via record replacement. Since Minnesota changed to electronic records for births in 2000, so 24 years ago, we no longer ask for parents' marital status.
Okay, thank you, Ms. Timian. Any questions from members of the committee or discussion? Anyone else here in the audience wish to speak to this bill? All right. Senator Pappas moves that Senate File 4860 be recommended to pass and be re-referred to the Senate Health and Human Services Committee. All those who support the motion say aye. 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 Opposed? Motion prevails. All right. Thank you.
Thank you. Thank you very much.
Is that the end of your time with us today, Senator Wiklund?
It is the end of my time with you,
All right.
yes.
Enjoy the
I
rest of your day.
appreciate that. Thank you.
You're welcome here anytime, of course. Senator Dibble, Senate File 4579. Members, the packet is being distributed. This bill comes to us from the Energy Committee, and there is an A6 amendment, so we'll ask Senator Dibble to give us a brief description of the bill. And then either Senator Dibble or Council can identify for us if any specific is the whole bill in front of us. Okay, Mr. Elwood might tell us. Yeah, jurisdiction. Okay. Okay, so Senator Dibble, tell us about the bill briefly, and then we'll have Council identify the provision before this committee, and then we'll consider your amendment.
Thank you, Mr. Chair, for the opportunity to present Senate File 4579 in front of the Judiciary Committee. I would also like to take the opportunity to thank my co-authors, Senators Pappas, Mitchell, Umuver-Baton, and Westland. Yes, Senate File 4579 comes to you from not one but two hearings in front of the Energy Committee. We had first one identified the issues. We went out, worked out a lot of the issues, and came back to great, widely shared support, but with also a little bit more work to do, which has happened since that time. And that's what the amendment in front of you reflects. But to the bill itself, first, very high-level overview, Mr. Chair. It does, as I implied, reflects extensive work among stakeholders. To my knowledge, there is no opposition to the bill at this time. The stakeholders involved were primarily the Minnesota Multi-Housing Association, a third-party billing company that assists in billing tenants in multifamily housing for their utility bills. What it seeks to do is to solve a disparity that exists right now in how tenants who live in shared meter buildings are treated as compared to those who live in individually metered buildings, or many of us who live in houses that of course are individually metered for our water, our gas, our electricity. Those who live in directly connected buildings enjoy many of the rights and the benefits and the protections as a customer of a utility that are available under the law, by virtue of rule, tariff, ordinance, and come under the protection and the authority of the Public Utilities Commission. Tenants who live in shared meter buildings have none of those protections. They're not the customers of a regulated utility. Their utility bills are passed through by an intermediary, housing providers, a third, sometimes a fourth party, third-party billing company. So the PUC, the Attorney General, the Department of Commerce, the utility companies, tenant advocates have all been getting complaints over the course of many years about issues around billing, accuracy, service, disconnection, implications for maintaining housing, evictions proceedings that might ensue as a result of problems with their utilities, et cetera. Plus, of course, no connection to payment plans, payment protection, budget plans, the conservation and efficiency programs, and on it goes. So the bill puts tenants in these shared meter buildings on the same footing as tenants who are in direct metered buildings and gives them all the protections that they would otherwise enjoy if they were a direct customer of a utility. Protection against shut-off in the winter, fairness in billing, access to a complaint process at the PUC. It provides for making sure that electricity sub-meters, in the case of meters and sub-meters, making sure that the sub-meters are accurate, and also ensures that the charges that tenants pay, whether through sub-metering or apportioning, that was a big discussion and part of the big resolution, the big coming together, solving a lot of the tension in the bill as introduced. So apportioning is permitted for gas and water. Will only reflect what the tenant uses and only their pro rata share of the fixed costs. And also should be mentioned that another source of tension allows housing providers or third-party billers to impose a billing fee per billing period, which is the equivalent of what a customer who is connected directly to Excel or CenterPoint would pay for the monthly service charge. It makes sure that tenants don't pay for the common usage or spaces occupied by the housing provider, another word for landlord, or property manager. And it prohibits utility service disconnection, but allows the housing provider to take action for breach if a utility is not paid, or utility bill is not paid. So with that, I believe the amendment is largely technical in nature. Either Mr. Elwood or Council Ben Stanley is not here, who actually has been working on all of this. He was up till, I don't know, some god-awful hour last night putting this amendment together. So I need to thank him publicly as well for all of his incredible hard work.
Thank you, Senator Dibble. Ms. Primo, could you tell us which provisions in the bill are specifically before this committee?
Mr. Chair and members, even though it does amend some energy-related statutes, the entire bill ends up being in our jurisdiction because it places obligations and duties upon the landlord with respect to the services they provide to tenants.
Mr. Elwood, did you want to describe the A6 amendment then? Is that my understanding of your plan here?
Mr. Chair and members, Ron Elwood with Legal Aid, thank you again for hearing this bill. The amendment is 99% technical. I think the one area, or a couple of the areas that are more substantive would be the amendment on line 1.12 and 1.13, where the amendment provides that all sub-meters have to meet a certain national standard. And the other sections of the bill are really more of a reordering and making it the underlying bill read more clearly. I think that's, and then starting on the amendment on line 4.12 and all the way down to 5.24 is primarily again, a reordering, but I would call your attention, that is where the apportionment provisions and the administrative billing charge is set forth clearly, that it's both allowed, but it's also specified. So I would say those are the highlights of the amendment.
Thank you, Mr. Elwood. Senator Dibble, Mr. Smith going to testify as well, or why don't you go ahead and Mr. Smith?
I think he's ready to say they're in support.
Mr. Smith, please identify yourself for the record.
Mr. Chair, members of the committee, my name is Cecil Smith. I'm the CEO of the Minnesota Multi-Housing Association. We are very grateful to Senator Dibble and the other stakeholders, especially legal aid and the hard work that Mr. Elwood has put in to helping us get to through a very positive collaboration and arrive at the bill that you have before you today. So we would urge passage of the bill.
Senator Pappas.
Mr. Chairman, if there are no questions from the committee, I would move the A6 amendment.
Are there any questions from the committee on the amendment? Senator Pappas moves adoption of the A6 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Anyone else in the room wish to come forward and testify on this bill? Any further comments from any of the testifiers? Mr. Elwood.
Mr. Chair and members, again, really appreciate Senator Dibble carrying the bill. Really want to thank Mr. Smith and the Multi-Housing Association, and I also want to make a special point to thank the Attorney General's office, specifically Ms. Catherine Kelly, who's been just instrumental in getting us to where we are, and also the Public Utilities Commission and their staff, which really provided enormous support and technical assistance on this bill, and I really want to appreciate all of their help in getting us to where we are today. Thank you.
Senator Dibble, I understand this goes back to energy from here. Is that your understanding, or where do you think it goes?
No, Mr. Chair, it's ready to go to the floor.
To the floor. All right. Okay. Then the motion from Senator Pappas is that Senate File 4579.
Mr. Chair?
I'm sorry, Senator Howe.
Thank you, Mr. Chair. And I just got one question regarding, this doesn't change the relationship when cities require that for utilities such as water and sewer, and they charge only they send the bill directly to the owner. This doesn't change that relationship between the city and that owner, where they doesn't make the city require the tenant to pay that or anything like that, does it? Doesn't change that relationship?
Senator Dibble.
Thank you, Mr. Chair. Senator Howe, that is correct. The water would be apportioned, and so the determination would be made, by the owner of the property, what the amount that the tenant would then pay to the owner then would pay the bill.
Senator Howe, any follow-up on that?
No, that's, just wanted a clarification, that's all. Thank you, Mr. Chair. Thank you, Senator Dibble.
Any other questions or discussion from members of the committee? Not seeing any. Senator Pappas, as a co-author on the bill, moves that Senate File 4579 as amended be recommended to pass and be sent to the Senate floor. All those in favor say aye.
Aye.
Opposed? Motion prevails.
Thank you, Mr. Chair and members.
Thank you, Senator Dibble. Senator Kreun. Senate File 38, House File 3868, Uniform Commercial Code Amendments. I know this is the one that everyone in the room has been waiting for this morning. It's the highlight of the pre-11 a.m. portion of the agenda. Senator Kreun, why don't you go ahead and tell us what the bill does? And I think all of it's within our jurisdiction, is that right? Because the entire Uniform Commercial Code. So members, you've got 132 pages to scan through while Senator Kreun's presenting the bill.
Thank you, Mr. Chair, and I'll talk long enough to make sure they have the opportunity to go through every page.
I might have to cut you off if you try that, Senator Kreun.
Not heavy, as everybody knows, but they've done pretty much.
Oops. Thank you, Mr. Chair, members of the committee.
Senator Kreun.
We have some amendments to the Uniform Commercial Code in front of you to accommodate emerging technologies and talk about flashbacks to law school. But if you'd have told me I would be presenting a bill on the Uniform Commercial Code when I was in law school, I don't think I would have believed it. But here I am. But luckily, I don't have to explain it because I have Kim Lowe next to me, who is a business attorney who volunteers countless hours to the Uniform Law Commission and is a subject matter expert on this topic.
Ms. Lowe, welcome to the committee.
Thank you, Chair Latz. Kim Lowe. I am, as Senator Kreun said, I am one of Minnesota's Uniform Law Commissioners. There are 11 of us. You see us often. I think we've presented before this committee already once this year, so I won't belabor what the Uniform Law Commission does. I'm also a business law attorney, and I'm also a member of the business law section of the Minnesota State Bar Association. These amendments to the Uniform Commercial Code, and I'm not going to belabor them because they are extensive, they create 5 different changes. The Uniform Commercial Code is regularly looked at by the American Bar Association, the American Lawyers Institute, and the Uniform Law Commission to make sure it stays current for changes in the world. As I think all of you know, we have had some technological changes over the last few years. It hasn't been open since, I think, maybe 2012. So as a result of some technological developments and changes, the Uniform Law Commission developed a whole series of amendments to the Uniform Commercial Code in 2022. At this point in time, these amendments have been adopted by 14 states and have been enacted or introduced in another 15. These amendments have been adopted in South Dakota, North Dakota. They are being introduced in Iowa. So we are kind of in the bullseye right now to get ours done. What the amendments really do is they create a new Article 12 to the Uniform Commercial Code called Controllable Electronic Records. I won't test any of the lawyers in the room because you were not, when you were in law school, this did not exist. It updates the Article 9, which is really the penultimate section of the Uniform Commercial Code, to allow for perfection and security interests in these digital assets, right? It takes these assets that are out there in commerce now and creates a mechanism to create a security interest in them. It creates new rules for mixed transactions involving both goods and services. It updates the rules for electronic negotiable instruments, and ultimately it updates terminology to account for electronic signatures and documents. That is a 5-point description of 132 pages, but I am here to answer any questions you may have about the particular amendments or any of other questions you may have about the Uniform Commercial Code.
Like Senator Kreun, I'm having some flashbacks here. Hopefully that's not the cause of my PTSD. It must be something else. Any members of the committee have any questions relating to House File 3868? Anyone else in the room wish to come forward and testify?
That's interesting.
All right. Senator Wiklund, would you like to move adoption of the bill? Let's just go to the Senate floor.
Mr. Chair, thanks, yes.
All right, Senator Wiklund moves that House File 3868 be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Ms. Lowe and Senator Kreun. Is Senator Maye Quade in the room? Okay, we're texting her. Otherwise. All right, members, we're going to go to Senate File 3492. As you can see, we're juggling the availability of members to fit our agenda order. Senator Mohamed, this is the Housing Policy Omnibus Bill. We heard an extensive list of housing policy Senate files. already in this committee, and so today we will be assembling the omnibus bill for housing policy. Staff is handing out the packet, which includes a delete everything amendment. Ms. Primo, if you would identify for us the provisions or the proposals that have been included in this proposed omnibus housing bill.
Mr. Chair and members, sections 1, 11, 12, 13, 14, and 17 are from Senate File 3748, which is Senator Gustafson's tenants' rights for victims of domestic violence and sexual abuse. This includes the A2 amendment and Senator Howe's oral amendment, making it immediately effective except for the penalties. Sections 2, 3, and 15 are Senator Mohamed's tenants' rights to organize bill, SF 3201, and includes the A2 that was adopted in committee, as well as Senator Kreun's oral amendment deleting non-commercial and inserting tenant organization. Section 4 is Senator Mohamed's Senate File 3587, which requires disclosure of the service and support animal law in all leases, and includes the A1 adopted by the committee. Section 5 is Senator Putnam's 3769, which requires landlords to at least offer the option of accepting an ITIN. Sections 6, 8, 18, 19, 20, and 21 is Senator Bolden's SF 3553, which makes several clarifying changes to 504B, including the service of the summons and complaint, early lease renewal, and late fees, and includes the A2 that was adopted by the committee. Section 7 is Senator Fateh's SF 3571, which provides a tenant with several remedies when construction is delayed construction is delayed, making the unit unavailable for use or occupancy, and includes the A4 adopted by the committee. Sections 9 and 10 is Senator Fa's 3979, which clarifies the tenant's right to call for police and emergency assistance in the event of a mental health or health crisis, and includes the A1, which was adopted by the committee. Section 16 is Senator Zhang's clarification on the definition of public housing for purposes of the 2023 Right to Counsel law, and it includes the A2, which was adopted by the committee, and that's SF 4465. I included a minor technical correction, which can be found at line 11.25, which inserts a specific citation to the continuing appropriation in the federal law to the specific section. This was a mistake that was not included in the A2 amendment. That concludes the content of the DE.
So, members, just to be clear, this is the chair's proposal for what should be in the omnibus housing bill here. Senator Mohamed brought Senate File 3492 to us, which contained a large number of these components within it. We also had some other Senate files that came to us separately, which are identified in the list that Ms. Primo just went over. For your information, I wanted to identify the provisions that we heard that are not included in this proposed omnibus housing bill. Senate the contents, the overall contents of Senate File 3492, which was broader, have been deleted in order to create, so we use the Senate file as a vehicle, and inserting with the delete everything amendment, then the contents that Ms. Primo described. Senate File 4015, which was the Fair Chance Housing Bill dealing with criminal convictions and conditional offers of tenancy, and that one is not included here. Senate File 2448, the tenant right to make repairs to the leased unit as well as common areas, is not included here. Senate File 3807, Senator Kupik's bill on radon testing is not included here. And Senate File 3489, the contract for deed provisions are not included here. So with that,
Chairman,
Senator Pappas.
I would move the A3 amendment.
Senator Pappas moves adoption of the A3 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Mohamed, this is the bill that the committee has put together for today. You're the chief author. So why don't you go ahead and tell us your thoughts on what we're doing here.
Thank you, Chair Latz. Obviously, we brought a lot of provisions to the committee, and you all have decided that this was what was going to go in, and so thank you, and I look forward to carrying this bill to the floor. And thank you for your time the other night. I know it was a very, very long night.
Thank you, Senator Mohamed. I want to commend you for the obviously great deal of work that went into all of the housing proposals that you brought forward to this committee. A lot of stakeholders involved, a lot of interesting policy provisions, and I thought we had a very healthy discussion in committee. So thank you for bringing all of those to us. What the chair is proposing here that's been adopted in the A3 amendment is what I perceive to be the consensus items that would have the committee's support for moving forward. So is there any discussion among members of the committee? Or I suppose I should ask if there's anyone in the room that wishes to come forward and testify in connection with this before we go any further. I'm not seeing anyone. Any members of the committee have any discussion, questions, conversation about this bill? Senator Pappas.
Mr. Chairman, obviously there are some bills that we heard that are not included here, and maybe some of them just need a little bit more work, and hope that they will return after some refinement and more discussions in the future.
Is there any further discussion? My understanding is that the next stop for this bill would be the Senate floor. Is that correct, Senator Mohamed?
That's correct, Chair Latz.
All right. So Senator Pappas moves that Senate 3492 as amended be recommended to pass and be sent to the Senate floor. All those in favor say aye.
Aye.
Aye. Opposed? Motion prevails. Senator Mohamed, it moves forward in your capable hands. Thank you very much.
Yep.
All right, Senator McQuaid, I think I saw you come in. There you are. Come on forward, please. We're going to go back to the agenda item, Senate File 3497, the Antenuptial Contract Bill. There is an A1 amendment to this. This is the first committee stop for this bill. So Senator Pappas moves adoption of the author's amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Maye Quade, why don't you tell us about your bill?
Thank you, Mr. Chair, members. Good morning. This bill, actually, it's very simple. It came to me from a constituent named Michelle. She pointed out that in our antenuptial contract statute, it currently says a man and a woman of legal age may enter into an antenuptial contract or settlement, and pointed out that that wouldn't cover a whole host of people who might be married or be getting married and entering into these contracts. So this bill simply changes that to two people of legal age may enter into an antenuptial contract. And then the amendment before you is a revisor instruction to change the terms husband, wife, husband and wife, husband or wife to spouse or spouses or similar terms wherever they appear in statute unless the context indicates that that previous term should remain.
Senator Maye Quade, do you have any testifiers you'd like us to hear from in this bill?
No, Mr. Chair.
Anyone in the room wish to come forward and testify in connection with it? Any discussion or questions from members of the committee? Not seeing any. Senator Wiklund moves that Senate File 3497 as amended be recommended to pass.
It's going to be late.
Actually, what we're going to do, I think, is lay this over so we can roll it into a larger bill. So with that said, Senate File 3497 is laid over.
Thank you.
And Senator Maye Quade, Senate File 3504, the Parentage Act. Members will have that bill distributed as well. Senator Maye Quade, why don't you go ahead and give us a description of that bill while we're distributing it to the members. And if you have testifiers, they can come forward as well.
Thank you, Mr. Chair. Thank you, everyone, for agreeing to hear Senate File 3504, the Pathways to Parentage Act. In 2017, the Uniform Law Commission, a nonprofit organization that drafts nonpartisan legislation in the areas of state law for which uniformity among the states is advisable, drafted the Uniform Parentage Act. The commission brought together a broad and expert stakeholder group, including family law attorneys, child protection officials, and public health experts, and worked to create a best practice framework to establish parent-child relationships in state law. Senate File 3504 takes the recommendations of the 2017 Uniform Law Commission and tailors two specific articles to Minnesota statute to define clear pathways to parentage for families who use assisted reproduction and/or surrogacy. Currently, the absence of clear, efficient pathways to parentage is harmful for families across Minnesota. The legal processes that exist now, such as second parent adoption, are often lengthy, costly, and place undue stress on parents and their children. I can speak from experience, as my wife and I had to go through that process to legally establish ourselves as our daughter's mothers. The lack of clear parentage pathways causes confusion and unnecessary litigation, and children are left more vulnerable because they are attached to only one of their two parents under law. This means that a parent may, for example, be unable to make emergency medical decisions for their child because they are not fully recognized as their child's parent. This happened to my wife and I last spring before our scheduled court hearing for second parent adoption took place. As you all know, my daughter got very sick and was hospitalized in the pediatric intensive care unit. The providers and staff at Children's were absolutely incredible, but my wife and I had this immense fear and anxiety above and beyond that of having a sick child because the law didn't recognize my daughter's mama as one of her legal parents. It was an extra unnecessary fear that I don't want any other Minnesota parents to experience. I want to thank Senate Council and staff as well as the many Minnesota stakeholders and experts for ensuring that this crucial first step for comprehensive guidance to Minnesotans building their family modernizes our parenting laws and, more importantly, gets us closer to equal treatment under the law for Minnesota families. And Mr. Chair, I'll turn it over to my testifiers.
I can start. Thank you. My name is Kreun. I am the executive director for Outfront Minnesota, our state's largest LGBTQ advocacy organization. And I just want to share, family is important to all of us. And it has been more than a decade since Minnesota passed same-sex marriage equality here in the state. And this is an opportunity to update our parentage laws. These updates will ensure that the rich diversity of our families and pathways to parentage are fully reflected in the law and are clear. This bill draws from the Uniform Parentage Act, as the senator shared, and provides a consistent framework to folks who are establishing pathways to parentage. For our LGBTQ families in particular, we frequently hear these stories and concerns around the recognition of our relationships and parentage, particularly in our current national legal landscape. And that may mean having to rely on things like the second parent adoption process in order to provide that clarity and support and legal recognition. But it's not just LGBTQ families who will be affected by this. It's crucial that we all have clearly established pathways to parentage here in the state, and this is one step towards adopting a broader set of updates to Minnesota's parentage laws that will continue to move us forward into the next years ahead. Let's make sure our laws reflect the experiences of all our families, and I urge you to support this bill.
Thank you for your testimony. Who's your next testifier, Senator Maye Quade?
Good morning, Chair Latz and committee members. My name is Julie Berman, and I live in Minnetonka. I am a former board chair for Resolve, the National Infertility Association. On behalf of the millions of women and men in the U.S. and the more than 185,000 Minnesotans who are trying to have babies in the face of infertility, Resolve supports Senate File 3504. 1 in 7 couples have trouble conceiving or carrying a pregnancy to term. Many people needing to conceive with the assistance of medical technology have spent years trying to conceive a child, and some of them turn to surrogacy to build their families. There are a number of reasons why intended parents turn to surrogacy, including heart disease, cancer, diabetes, and hysterectomies. Surrogacy is also important for many in the LGBTQ community to have a biological child. The American Congress of Obstetricians and Gynecologists, the American Society for Reproductive Medicine, and the Academy of Adoption and Assisted Reproduction Attorneys all support surrogacy as a safe family-building option. As the voice of the 1 in 7 who face infertility and other Minnesotans who rely on assisted reproductive technologies to build their families, Resolve supports this pro-family bill. Thank you.
Thank you. I have Patience Griswold, who appears on our screens. Ms. Griswold, go ahead.
Thank you, Chair Latz and members. My name is Patience Griswold. I'm the engagement coordinator at Them Before Us. Under this bill, what makes someone the parent of a child is not the natural biological bond that exists between them, nor adoption, an arrangement that is designed with the child's best interest in mind, and thus requires rigorous background checks and screening of the adults involved. Rather, it establishes parentage on the basis of adult intent. Surrogacy turns children into commodities to be awarded with adults with the money and means to acquire them. Furthermore, it creates a class of people who can be sold. A child who is genetically related to the woman who carries him cannot be exchanged for money. Under this legislation, a child who is created with donor gametes and carried by a surrogate can be. Even when a child of surrogacy is raised by their genetic parents, they experience the trauma of maternal loss when they are separated from their birth mother. Mother-child bonding begins in utero. By the time a baby is born, she knows her mother's voice and smell and has been responding to her emotions. Studies show that maternal separation is a major physiological stressor for an infant, and even brief maternal deprivation can alter the structure of an infant's brain. We urge you to consider the perspective of children who have been victimized by this industry. Brian, a child of surrogacy, wrote, "Babies are not commodities. Babies are human beings. How do you think it makes us feel to know that there was money exchanged for us?" Olivia, another child of surrogacy, put it this way, "I lived it as an abandonment. I feel as if I was abandoned by my birth mother." Additionally, research has found that 70% of donor-conceived adults believe that society should not encourage gamete donation, and 62% said they found the commercial nature of gamete donation to be unethical. Children are people, not products to be commissioned, swapped, sold, or traded under contract. They deserve to have their rights protected. As one donor-conceived individual put it, third-party reproduction is not a new way to create families. It is a new way to rip them apart. Thank you for your time.
Thank you for your testimony, Ms. Griswold. And I also have on here Rebecca Delahunt has signed up to testify. Is Ms. Delahunt here? Coming forward.
I work as the Director of Public Policy with Minnesota Family Council. On December 6, 1865, the USA ratified the 13th Amendment, which banned slavery in the United States. Yet the Minnesota legislature is considering a policy in 2024 to regulate the trade of children, opening the door to the legal buying and selling of children through surrogacy. How is it possible to wholeheartedly support the 13th Amendment of the United States, but then try to legalize the selling of children to unrelated adults in 2024? In surrogacy, the gestational surrogate is impregnated with an embryo by IVF, either with gametes from intended parents, donors, or a combination. The gestational surrogate then delivers the child to the intended parents, and an intended parent could be biologically related or unrelated. Children are already facing significant mental health struggles and identity craving. What will happen when we create a sizable population of them who are cut off from their mother and/or father? Children have a natural right to their biological mother and father. We all understand people crave to know where they're from. It's why some adopted children face what has been called the primal wound. They sense the loss of being cut off from their biological identity. But adoption is different than surrogacy because in adoption, the child was not created with the intention of separating him or her from parents. Adoption is legally set up to facilitate children's best interests. Surrogacy provides intended parents with a product that they are sometimes willing to pay for. One is focused on justice for children who cannot advocate for themselves. The other is a marketplace for adults to pay for potentially unrelated children. These children are the key stakeholder of this proposed policy, but they don't have a seat at this powerful table. Surrogacy creates two classes of people, those who can buy children and the women who are sometimes doing this to meet a financial need. Exploiting women's bodies like this is wrong. How is the renting of wombs ethical or the trading of children any different than human trafficking? It's not, and that's why I'm asking you to vote no on SF 3504. Thank you for your time.
Thank you, Ms. Delahunt, for your testimony. Anyone else in the room wish to come forward and testify in connection with this bill? I'm not seeing any. We do have a delete everything amendment, the A12 amendment. This is the first stop for this bill, so it's an author's amendment. Senator Pappas moves adoption of the A12. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Maye Quade, can you tell us what the difference is between the A12 and the underlying bill?
Yes, Mr. Chair. The major difference between the underlying bill and the DE is that this focuses specifically just on gestational surrogacy and then assisted reproduction. The underlying bill included a lot of different things. It was basically a lot of the Parentage Act, and from my understanding, we're not ready here in Minnesota to adopt all of those things, so this has just been whittled down. There are some language updates, so it'll say, you know, individual or the person who gave birth instead of some of the gendered language, but the intent effect of the bill remains the same, it's just smaller.
All right, any questions or discussion among members of the committee? Senator Limmer.
Thank you, Mr. Chairman. Senator Maye Quade, are you familiar with a former legislative commission regarding surrogacy that was conducted a few years ago?
Senator Maye Quade.
Thank you, Mr. Chair, and Senator Limmer. I'm familiar with its existence. I believe it existed around the time I served in the other body.
And
Senator Limmer.
Could you tell me if this bill follows that surrogacy commission in their recommendations, or does it differ?
Senator Maye Quade.
Thank you, Mr. Chair and Senator Limmer. I'm not familiar with the details of the commission's recommendations, but I do know that one of the recommendations is that we have a regulatory framework for surrogacy, and this bill does do that.
Okay. I'm trying to remember, pardon me, Mr. Chair. I'm trying to remember the surrogacy commission recommendations myself. However, some of the concerns that I remember being raised was the possible exploitation of women, especially those that might be in a poorer economic stratus. And have you considered any of those factors in writing this? I see that one can recommend payment for a woman holding a child or holding a child during pregnancy, and yet the expenses can exceed reasonable expenses as well. Could you explain how far that monetary award could grow in a situation like that?
Senator Maye Quade.
Thank you, Mr. Chair and Senator Limmer. So the bill does allow for that to happen. It doesn't require that to happen. And part of the reason, to your earlier part of the question, for taking into consideration ways to deal with possible exploitation, having in statute requirements around agreements and contracts is the best way that we can address that, because, for example, in this bill, it requires that a surrogate have an independent attorney, so somebody who is helping craft the legal requirements in the framework of their surrogacy agreement based solely on the interests of that person. Right now, because we have nothing in law, it would be at the best interests of the people, or it would be at the whim of the people entering into the agreement. So having this framework in law deals with some of the concerns around exploitation that you're experiencing, particularly in having independent representation to ensure that the interests of the surrogate are being met as well as the intended parents.
So, Mr. Chair.
Senator Limmer.
Senator, in the event that the person is of low economic status, are they required for that, to pay for that individual attorney, or will one be provided for them?
Senator Maye Quade.
Thank you, Mr. Chair and Senator Limmer. If you look at 7.9 of the A12, the intended parent or parents must pay for independent legal representation for the surrogate.
Senator Limmer.
I'm trying to get to that reference, Mr. Chair. 7.9, did you say? I must have a different.
Senator Pappas. One moment, Senator Limmer.
Thank you, Mr. Chairman. Senator Limmer, I actually served on that commission, and there were actually two reports, two recommendations. So the commission was split, and there was half the commission which felt that really surrogacy should not be allowed, and the other half of the commission which recognized that surrogacy was currently going on and was an option, like in vitro fertilization it has become for many families, and people want to kind of grow their families when they're infertile or unable, and that although the surrogacy community has been very strict in following best practices, which I assume this bill follows a lot of what they're doing already, and a lot of that is making sure that the surrogate has legal representation and is properly compensated for, and for the risk that they're taking, frankly, because childbirth is a risk. So not just the expenses, but the time. You might have to take off work and do bed rest or something to protect the fetus. So I'm very happy to see this bill coming forward, and hope that we can get it passed.
Senator Limmer.
Thank you, Mr. Chair. Senator, I found that reference 7.9 and 10. The intended parent or parents must pay for independent legal representation for the surrogate. Who chooses the hiring of that attorney? Is it the intended parents, or is it the surrogate in this case? And then who is the attorney loyal to if someone else is paying the bill? And maybe not a friendly partner to this arrangement. It could happen in a contractual 9-month period of time.
Senator Maye Quade.
Thank you, Mr. Chair and Senator Limmer. The surrogate gets to choose their legal representation, and part of the reason why we have this laid out is to allow throughout the entirety of the contractual agreement for independent representation. You'll notice throughout the description of the gestational surrogacy agreement requirements, it allows for termination of the agreement, and it lays out specific things that way. And so, most people who enter into a contract for surrogacy, both the intended parent or parents and the surrogate, do so willingly and excitedly, right? They both have sought out to be matched to do this. The independent legal representation is loyal to the person they're representing, so the independent representation for the surrogate and the independent representation for the intended parent or parents. And so that's whose best interest would be in mind for a contractual negotiation.
Mr. Chair.
Senator Limmer.
During the period of pregnancy, can a contract be negated?
Senator Maye Quade.
Thank you, Mr. Chair. And Senator Lemmer, when you say can a contract be negated, can you just say two more things so I understand the question you're asking me?
Senator Limmer.
Mr. Chair, can the contract for surrogacy be canceled in the middle of a pregnancy?
Senator Maye Quade.
Thank you, Mr. Chair and Senator Limmer. So if you look at 9.19, that's the start of the termination of gestational surrogacy agreement. A party to the agreement, starting on 9.21, may terminate the agreement at any time before the embryo transfer. If the embryo transfer does not result in a pregnancy, they may terminate the agreement at any time. And then, there's additional pieces throughout there. But if a person is pregnant, there are obviously situations that arise during a pregnancy that might see whether the pregnancy continues or not, but it does not allow for the cancellation of an agreement during a pregnancy just because.
Mr. Chair, I understand the line 9.22 about any time before an embryo transfer. For lack of a better term, that would be before conception occurs. But after conception, and there may be some physical factors that could terminate a pregnancy. But a contract then cannot be canceled in any way. Can a party violate the contract?
Senator Maye Quade.
Thank you, Mr. Chair and Senator Limmer. People can violate contracts in the way that contract violations can occur. And I have a family law expert next to me who can maybe talk about maybe some of these specific situations. But would you mind actually just maybe asking very directly, maybe using an example or a specific situation that you're thinking of in your head? Because I think I might be getting caught up on can someone violate a contract? They can. Can you just talk a little bit more about the situation you might be worried about?
Senator Limmer, do you have a specific example in mind?
I hate to bring up a hypothetical, but I'll bring up a hypothetical. Let's say there's two parties. They arrange a surrogacy contract, conception is created, and after conception, someone wants to back out of the intention of having a child. If that would occur, the real question is, what happens to the child?
Senator Maye Quade.
Thank you, Mr.
Do you
Chair.
want the lawyer to your right to answer the question, or do you want to do it?
Mr. Chair, it's a very easy answer, but I can let the lawyer follow up. But
Senator Maye Quade.
Thank you, Mr. Chair. Senator Limmer. So the way that the parentage is laid out based on surrogacy agreements in this document is that intended parents are the parents of the child. And so that just is, right? If the child is born and there's a surrogacy agreement, that child is the intended parents, whether they want it anymore or not, right? That becomes a whole separate discussion, but that is how the parentage is ordered here. And I can have the lawyer speak to that more.
Sir, go ahead and identify your name.
Yes, good morning, Your Honors. My name is Gary Dibble, and I'm an attorney in Minneapolis. I head up the family practice group at Messerly Kramer. I have been practicing family law for 37 years, doing surrogacy work for more than 25 years. I was involved in putting this bill together based on the Uniform Parentage Act. I'll address Senator Limmer's question because over the years I have seen some issues with contracts being challenged. It's a breach of contract. If either side decides they don't want to go forward with it, there can be damages, meaning there could be a financial compensation if that's appropriate. There is a specific performance component to contract enforcement, but this bill is crystal clear that the carrier cannot be forced to carry the pregnancy or be forced to give up the pregnancy if, there is no specific performance for that part of it. So I think the parties are all protected in terms of contract enforcement. There could be damages. If the carrier backed out, she might have to give back the money that was paid as part of the contract. If the intended parents backed out, the carrier would have the right to parent that child if she wanted, or the child could be placed for adoption, or the intended parents could be forced to honor the contract as well. At that point, if the intended parents refused to take the child, you'd have a child protection issue and there'd be all sorts of other protections in place. But these are contracts. I mean, their contracts and, similar enforcement mechanisms are in play, with the notable exception of you cannot force a woman to give birth to a child or to give up the child, have an adoption, terminate the pregnancy.
Mr. Chair.
Senator Limmer.
Mr. Chair, if the intended parent is considered the parent, and yet you have the other party that's carrying the child, where does the right of abortion fall on who? Is it on the intended parent, or is it on the woman carrying the child if there was a breach in contract?
Senator Maye Quade.
Mr. Chair, Senator Limmer, if you look at 8.6, the agreement must permit the surrogate to make all health and welfare decisions regarding themselves and their pregnancy. This chapter does not enlarge or diminish the surrogate's right to terminate the pregnancy. So a person who is pregnant, whether they are a surrogate or not, retains the ability to have reproductive freedom and control over their body. So I'm assuming there might be contractual violations that could arise from that, but they have control over that decision over their own body.
Yes, I'll tell you I'm sorry. May I answer?
Yeah, go ahead. Just for the record, I have to announce who's speaking, so anyone reviewing this someday would know.
So we spend a lot of time in these contracts negotiating a termination of the pregnancy. Who will decide under what circumstances? And in fact, reputable agencies that match the parties to these agreements spend a lot of time discussing that with the parties, making sure there's agreement between the parties of what is your view of selective reduction, termination, abortion, because you want the contract to reflect the agreement of the parties so they're mutually agreeable to what they want to see happen. Quite frankly, we've had very little litigation over the years that we've been doing these over that particular issue. The parties are generally pretty well matched and pretty well in sync on what they want to do, and the contracts lay out specifically what would be the basis for terminating the pregnancy. When you make those decisions? And so there really hasn't been a lot of problem with that.
Thank you.
Senator Pappas.
Thank you, Mr. Chairman. I just want to point out to the committee a letter from the Surrogacy Center, who's been working with families over 22 years. So we look at what the practice has been, and they've had actually 0 clients who have expressed regret or dismay about the process in any way. They've had no lawsuits or actions promulgated against them. So in Minnesota, at any rate, the organizations or entities that have been supporting surrogacy have followed all the best practices and made sure that all the parties were protected and all the contracts were clear and have had very successful outcomes.
Any further committee discussion or questions? Senator Kreun.
Thank you, Mr. Chair. This could be for the chief author or the lawyer. What is the current state of the law in terms of whether or not courts honor these types of agreements?
Senator Maye Quade. Mr. Dibble.
Yes, it's one of the reasons we're here with this bill is because we really have no law specifically addressing surrogacy in particular, and even assisted reproduction in general is pretty vaguely mentioned. There's one antiquated provision in the current Parentage Act of Chapter 257 that addresses artificial insemination between a man and a woman under medical supervision. We're way beyond that in terms of the only form of assisted reproduction. And so as a result, we have been practicing in this area, and surrogacy has been going on for more than 25 years in Minnesota. I've probably done hundreds of them in my career. And what this bill does is it brings a very simplified, unified product that really recognizes what we've been doing all along, but gives it some clarity. For example, one of the issues we have long disputed in Minnesota is, can you get a pre-birth parentage order as to the child, or do you have to wait until after the child is born? We have 87 counties in Minnesota. 3 counties, Hennepin, Dakota, and Ramsey, will not do pre-birth orders. We've done pre-birth orders in all the other counties in the state where they allow it, because it's not clear. If you're under the Parentage Act, figuring this out, you cannot adjudicate parentage until after a child is born. If we go in under a declaratory judgment petition, which is outside of the Parentage Act, there's not that restriction, and many judges do that. The hospitals, the intended parents, the carriers, the lawyers all prefer a pre-birth parentage order, so everybody knows when this child is born who the parents are going to be and what's going to happen at the hospital. So this statute, in a very elegant way, in my opinion, it tracks the uniform parentage law provisions, which have been vetted by scholars, judges, attorneys across the country, brings that to Minnesota. So we will finally have some uniformity in how we do surrogacy specifically, and also assisted reproduction just generally. So it's the law, to answer your question, it doesn't exist. We have one unpublished Court of Appeals case that dealt with a dispute between an single intended parent and a carrier, whether he should get the child. The Court of Appeals said, as a matter of public policy, these contracts are not in violation of public policy, and they enforced the contract based on just common law. That's the only law we have in terms of appellate law. The Minnesota Supreme Court has issued an administrative directive as to how to open these cases, how you caption them, which part of the court system deals with them, but they didn't address the substantive law. So this bill really fills a needed void in our law to really recognize what's been going on anyway, but to make it legally enforceable, clear, crystal clear. All the parties know they're all protected. It's really a good, solid bill in terms of reflecting current practice.
Senator Kreun.
Thank you, Mr. Chair. So if I heard you right, courts, at least according to one Court of Appeals decision, they do honor these contracts.
Right.
Yet there's only one appellate case. Is that true?
It speaks to the fact that there's not I'm sorry, my left just...
Just so,
I don't know
the proper protocol, this is not, you even called me Your Honor at the beginning of your testimony, which I know, because I made the same mistake. I made the same mistake last committee I testified in front of, too. Okay. It's sort of routine for lawyers who appear in court. But the proper protocol is to address the question through the chair and then to the senator that asked the question, just so you know.
I'll do better.
No problem.
So I'll respond.
There's nothing called contempt of chair, so you don't have to worry about that.
Not yet.
So I think...
Not formally, anyway.
I think the fact that we only have one non-precedential, is what they call them, a non-precedential appellate court decision in Minnesota, speaks to the fact that these are not terribly contested, controversial proceedings. They're happening, and they've been happening for a long time, and people come together because they want to do this. Nobody's forcing them. They go through the steps, and they want to have a legally solid parentage determination when they get to the end of it all. And so, the disputes, I've been an expert witness across the country on disputes, they're very few and far between. And so therefore you don't get a lot of appellate case law developing. And usually the ones where you have got those cases, they were like a really horrific situation where people were not represented, they entered into contracts that were ill-advised, they were, just unusual, highly unusual situations. And again, this bill will go a long way towards getting everybody on the same page. Who gets represented, what goes into these contracts, how do you enforce them, how do you get a parentage order, which is the ultimate goal. And like I say, this is the gold standard of what the law should be, and it's been carefully vetted, and it would be a wonderful thing if it were enacted here in Minnesota.
Senator Kreun.
Thank you, Mr. Chair. Of course, I think that it's a bit of a legal gray area, or there isn't any legal infrastructure around this, which is what you're trying to do with this bill. And you say you haven't been involved in a lot of disputes in these types of agreements, but of course, I'm assuming one of the goals of this is to provide that legal structure, which would logically then create more of these agreements, which of course then could create more potential issues with these agreements too. So even if you haven't had a lot of experience with disputes in these contracts, certainly if this bill were to pass, you could have a lot more, because a lot more of these would be going on. So, but the next question I had is because I'm just a little unclear on this. And I'm not opposed to surrogacy, and I don't want anything I'm saying to be construed that way, but I do get a little uncomfortable if we're talking about for-profit endeavors. And so could you tell me what the current state of the law is in terms of whether or not you can pay a surrogate more than the expenses associated with the surrogacy, and what this bill would do in that regard.
Mr. Dibble.
Yes, thank you, Senator Latz. So compensation is always a difficult question in this whole area of practice, and you'll see that the bill very carefully, and this has been, this bill, by the way, has been, this portion of the Uniform Parentage Act of 2017 has now been enacted in 6 or 7 states, and it's being carefully considered in a number of other states. And I know the states where it's been enacted, there has not been a surge of litigation. In fact, it's probably been the reverse of that, because now people know, the courts know exactly what the rules are and everybody follows them. It's purposely left open to say that compensation is allowed, and the courts have the ability to review all of that to determine what is being compensated. But we've always been careful in this area of practice is we're not paying for the child. We're not buying and selling genetic material. The compensation is a couple of things, components. One is actually compensating for out-of-pocket actual expenses. So maternity clothing, medical expenses not covered by insurance. Those are crystal clear and they're laid out. Even all the medical procedures that are covered, because as somebody indicated, pregnancies are unpredictable. You don't know what's going to come up. So those get covered. But then there also is consideration is the term that's given to compensate the carrier for her lost time, effort, what she's doing, and the risks that she's taking. And that's not unusual. We compensate all sorts of circumstances for that. And those rates get set, they vary across the country, they vary from case to case. I will have cases involving close friends or relatives, and they don't want that additional compensation. Others, they've got the agencies help people come up with a number, and so the numbers range across the country depending on where you're at. But we have found, when looking at this, if you outlaw compensation, as a few states have done, Michigan, for example, and they just changed it, they just passed a new law getting rid of that, it diminishes, if not eliminates, surrogacy. Because while there are a lot of people who do it with family members and don't get the consideration paid for, other people can't find gestational carriers and surrogates to work for if there's not that compensation piece of it, that consideration. And so this is a compromise, I would submit, that we allow it to occur. The courts will always have the chance to review it. The parties can raise the issue. The lawyers, when they're negotiating, will deal with it. So it's not something that's being imposed on the parties. It's to be negotiated, and it's to be set with what the parties think is fair and equitable, and ultimately what a court thinks is fair and equitable.
Senator Kreun.
Thank you, Mr. Chair. Of course, I use the word profit, you use the word consideration. At what point does consideration become profit? I guess, that's what I'm getting at here. And the more profit that is associated with this, the more profit market, the more troublesome this whole thing becomes, in my view, and the higher the possibility of exploitation and that sort of thing, if we're creating a market for profit. But you mentioned, what I heard was, well, the courts always have the inherent right to review the consideration in these contracts, but by what standard would the court review that by?
Mr. Dibble.
I would assume a court would apply in this context what they apply in every context. Is the compensation, is the money that's being paid for the service, is the consideration that's being given reasonable under the circumstances? I mean, we have a lot of areas of law where we don't lay out how you're going to be compensated in the amount. So parties negotiate that in contracts. Courts review that when there's a dispute. I don't think this area is any different than anything else. And this idea of exploitation, again, these are people that are willingly and freely contracting. If somebody doesn't believe in surrogacy, then they're not going to do it. But if people who are doing it to build their families are doing it, they've got lawyers. There's lawyers on both sides. The lawyers, even the carrier is not even having to pay for her own lawyer. So there's not an economic disadvantage there either. And I think, again, we have to recognize that we still have the right to contract in this country, and that this is what this is. It's a contract, and there's protections in place, significant protections, I would submit, in this whole process and in this bill, in the way we've been doing surrogacy for all these years. And again, I want to point out that we've been doing this in Minnesota for 25 years. This idea that from some of the people that we should outlaw surrogacy, well, that train left the station a while ago, I'm sorry to say. This has been happening. And we haven't had a lot of litigation. Again, one unreported Court of Appeals decision in all these years. And so it's, this idea that somehow people are being exploited, I don't think is supported by what's actually happening.
Mr. Chair.
Senator Maye Quade.
Thank you, Mr. Chair. And just to speak a little bit to it as well, putting regulatory framework around a thing that's already happening just ensures that there's consistency in every county for every Minnesotan across the state. And I really worry about us talking about like creating the market. Pregnancy is not a neutral state. It is literally like running a marathon for 40 weeks. That is the physical toll that pregnancy takes on your body, not to mention the emotional, mental toll. And so I really want us to move away from this idea that the only thing that is preventing or that is keeping people from not just like joining up to be surrogates is the fact that we don't have this regulatory framework. That is what's actually creating the potential for exploitation. It's what's creating the potential for things to be happening outside of this, and I love this term, gold standard type of legislation to make sure that every organization in Minnesota that works to match surrogates and intended parents are doing this wonderfully. And that's why we've had so few cases over the years. But anything that's happening outside of that, we don't know. And so we want to make sure that this legal framework that takes the best practice and puts it into law so that every single person who, is a surrogate in Minnesota, is an intended parent in Minnesota, is protected.
So I do not wish to unnecessarily truncate the conversation, but I will let you know that it's the intent to lay this bill over for possible inclusion in the Judiciary Omnibus Policy Bill. So there will be further opportunity when that comes before this committee to have conversation. I'll note we do have a lot left on the agenda we want to get to. So Senator Kreun.
Thank you, Mr. Chair. With that in mind, I'll just do one more question and then can move on to others. Appreciate that. And certainly, like I said before, I'm not advocating to end surrogacy. I think you can have concerns about this bill without taking the position that you want to end it. And that's where I'm coming from here, just to be clear. And certainly I'm all for free markets and free enterprise. I promote that in all sorts of different areas, and the people's rights to, their right to contract, adults contracting. I'm all for that. But when you start talking about, these are babies and these are children at the end of the day, I get uncomfortable with a for-profit, the potential for for-profit market of babies. That's just something that kind of raises it to a different level. But my last question, in the interest of time here, and is getting back to what the courts, you said, well, courts decide all the time what, if consideration is reasonable under the circumstances. But if we don't have a public policy in place about payments above and beyond reasonable expenses, I still don't understand how a court goes to evaluate whether it's reasonable. If this is a de facto way to say, yes, profit is okay in this endeavor, then how is a court supposed to determine whether that's reasonable? If the public policy of the state were, expenses, then a court could then have a standard to determine what is reasonable. But if there is no public policy, I don't know. It seems like there really isn't a court limitation that could be involved here. So I don't know if that's a question or just a comment, but again, I don't want to end surrogacy. There's nothing in my comment should be construed that way, but I have serious concerns about this particular bill.
All right, is there any further discussion from members of the committee? Not seeing any. Senate File 3504 as amended will be laid over for possible inclusion in the Judiciary Omnibus Policy Bill. Thank you, Senator McQuaid and members.
Thank you.
Senator Gustafson, we're going to take up Senate File 4891. If you have a witness, that witness can join you at the testifier table as well. Senator Gustafson, whenever you're ready, members, the packet is being distributed with the bill as well. If you go ahead and describe your bill when you're ready.
Thank you, Mr. Chair. SF 4891 is just a technical bill that conforms changes to the Administrative Procedure Act and Office of an Administration Hearings provision. It does the following. There's some technical things that it does that are pretty straightforward, but I'll let my testifiers speak to those. Before we get started, there is an amendment.
This is not the first committee stop, so it's not an author's amendment. So why don't we hear the description of the bill and the testimony regarding the bill, and then we'll consider the amendment.
Sure, thank you, Mr. Chair. I will let my testifier introduce herself and begin with the technical changes.
Judge Starr, welcome.
Yeah.
Why don't you go ahead and just identify yourself for the record.
Mr. Chair, members of the committee, I'm Jenny Starr. I'm the Chief Administrative Law Judge at the Office of Administrative Hearings. I believe you have before you the first engrossment that already adopts the author's amendment from the prior committee
That's
hearing.
correct, we do, Judge.
Okay. So I was just going to give you a quick overview of Article 1, the data practices article, which is my understanding is the jurisdiction of this committee.
That's correct. That's the only provision before this committee.
Okay, Mr. Chair, members, Article 1, data practices, works to bring the Minnesota Rules of Public Access to Records of the judicial branch. It works to change Minnesota statutes as it applies to the executive branch courts, the Minnesota Tax Court, the Workers' Compensation Court of Appeals, and the Office of Administrative Hearings into conformity with those provisions of the judicial branch that are appropriate for the administrative branch courts as well. And those three items are making judicial work product at an administrative court protected, non-public, and confidential data. And what that means is that the notes that I take when I hear a case, or the notes that I make to myself as I'm researching and deciding the matter, would be protected data. The item that becomes public and available to the parties is my decision at the end of my thinking process. This article also protects health-related documents and data that might be offered into evidence appropriately for the deciding of a case, but would not be appropriately distributed to a member of the public if they were interested in the case file. And thirdly, the item that the member of the public would receive is any factual findings or legal analysis that the adjudicator made in their decision that might have relied on those health-related documents. So these three provisions are, we hope, reasonable items that we have identified as they apply to the judicial branch courts, and ask that you bring the executive branch courts into conformity.
Thank you, Judge Starr. Ms. Primo, could you tell us what the A240252 amendment does?
Mr. Chair and members, I think the A240252 amendment was already adopted in the previous committee, unless there's another amendment that is being proposed.
All right, then let's set that aside. Senator Gustafson, are you aware of any other amendments that are proposed for this bill?
Mr. Chair, no, I'm sorry, that was a paperwork error on our part, so it is in the shape that we want it to be in.
Another tree falls, Senator Gustafson. All right, anyone else in the room want to testify on the administrative law bill before us? Any questions or comments from members of the committee? Let's see, where does this go from here? Do you want this to go back to State Gov, or do you want it to go to the floor?
Mr. Chair, I believe this goes back to State Gov to be included in an omnibus bill.
Okay. Senator Carlson moves that Senate File 4891 be recommended to pass and be re-referred to the State Government Committee. All in favor? Say aye. Aye. Opposed? Motion prevails. Thank you, Senator Gustafson. Okay, so members, we're going to take up Senate File 4960. This is my bill, so Senator Uma Verbaeten is going to take over the chair.
Madam Chair. Madam Chair.
Senator Latz, when you're ready. Senator Lemert?
Yes, Madam Chair, I see that we're coming to the end of our first page of agenda items, and we're now moving into another list. Is that list available to the members?
Thanks for the question, Senator Limmer. I believe our committee staff are working on preparing the new list for our members.
And when will we be getting that list?
I think if we could proceed with Senator Latz's bill at the moment, hopefully as we're hearing the explanation and the testimony from the witness, our staff will have some time to print the next page of the agenda for us.
All right, thank you.
Senator Latz.
Madam Chair and members, Senate File 4960 deals with the State Correctional Facilities Security Audit Group. Make some modifications to that statute. I do have an A1 amendment, which would be in the nature of an author's amendment, so I move its adoption.
Senator Latz moves the A1 author's amendment. All those in favor say aye. Aye. Opposed? Okay, the motion prevails and the amendment's adopted.
Madam Chair, I do have a testifier who can give a detailed description of the bill.
Wonderful. If you could begin by just stating your name, title, and affiliation for us.
Thank you. Margaret Zadra, Ombudsperson for Corrections. Good morning, Madam Chair, Senator Latz, members. I'm really grateful to be here this morning to talk about the State Correctional Facilities Security Audit Group and SF 4960. The Security Audit Group was developed in response to recommendations from the 2020 OLA report in order to provide some oversight and accountability within state prisons. So we have now been at this work for just over 2 years. The group has reviewed and adopted standards and have now made recommendations for each Minnesota prison. During that process, several opportunities have arisen to better utilize the group to ensure safe and secure facilities. Changes are recommended to prioritize the following. For membership, we are recommending expanding to include other state agencies with expertise in health and safety, infrastructure, and compliance, which are the Department of Health and Department of Administration. Broaden the language for the consultant position to allow for more applicants. There has been some significant challenges in recruiting qualified candidates to that position. Designation of the chair to efficiently utilize group time, clearer reporting on audit standards, clarification on exemption from open meeting law, given the review of security information, and application of 15059 advisory councils and committees. There's also some opportunities here for timing and frequency of meetings so that the group can review more than one audit at each meeting and can better utilize the group's time, be a little bit more efficient and effective with our work. This allows for us to address some of those higher level concerns, and lower level issues can be addressed internally at the facility. And with that, I don't, that covers pretty much everything, but I'm open to any questions you may have or any concerns.
Senator Latz? Okay.
Nothing to add. We're available to answer questions.
Okay. Seeing none, Senator Latz moves that Senate File 4960 as amended be recommended to pass and re-referred to the Senate floor. All those in favor say aye. Aye. Opposed? Okay. Motion prevails and Senate File 4960 is sent to the floor.
Thank you, members.
Next, we'll hear Senate File 3972, Senator Mann.
Senator Mann, 3972 on aerosol dusters. This comes to us, I believe, from the Commerce Committee. Is that right?
That is correct, Mr. Chair. Members, Senate File 3972 seeks to keep children out of the Minnesota emergency rooms and to keep them from dying from the abusive inhalants that contain fluorinated hydrocarbons called difluoroethane, or DFE. DFE is a liquefied gas found in cans of compressed air used to dust electronic equipment. Cans of dust-off are perhaps the ones you're most familiar with. When inhaled or huffed, DFE contains psychoactive properties that can cause a high that is short but very intense, and it is very addicting. But aside from that high, DFE can cause asphyxiation, seizures, heart attacks, flash pulmonary edema, and death. Withdrawal causes agitation, hallucinations, and psychosis. Nationally, about 2.2 million people report inhalant use, including almost 4% of 8th graders, 2.4% of 10th graders, and 1.8% of 12th graders, and it kills about 100 to 200 people per year. In the last 3 years in Minnesota, 8 people have died between the ages of 17 and 48. And while this number might seem small, we are also talking about addiction treatment, and we were talking about thousands of emergency room visits, including visits for withdrawal symptoms, as again, this product causes addiction and dependence. The bill makes it so that duster products with DFE cannot be sold to anyone under 21, must be held behind the counter, and no more than 3 cans can be sold to one person at a time, and also cans must have a warning label. With that, Mr. Chair, I do have some testifiers.
Thank you, members. I'm just going to identify for you the reason this bill is before the Judiciary Committee is the penalty provision in subdivision 6. That's on page 3. It is a misdemeanor, which is a default that we no longer see on a regular basis in this committee, but there's also an affirmative defense in there, which is something for us to be alerted to. And I will ask that the testimony focus on that provision which brought this bill to our committee. If we need a minute as a preface, that's fine, but we're only going to focus our conversation on the part that's before the committee. So we have a testifier here, Samantha Lee. You are on Zoom, Dr. Lee, so welcome to the Judiciary Committee. Again, if you could try to keep your testimony down to a minute or two, except for anything specifically focused on our jurisdiction.
Thank you. Dear Mr. Chair and committee, my name is Samantha Lee. I'm the director of the Poison Center and a pharmacist and clinical toxicologist. Our Poison Center has managed close to 100 cases related to air duster misuse in Minnesota over the last 5 years, which is an underreported number since calling the Poison Center is voluntary. A lot of these cases involve individuals in their 20s and 30s, really a vulnerable demographic, often unaware of the risks associated with huffing, inhaling the DFE air dusters. And nationally, poison center studies have found that these do result in serious medical outcomes. As Senator Mann stated, the biggest concern is it has a lot of health risks and potential for death, especially from some sniffing death syndrome. And really the provisions here, with the sale restriction and prominent health warnings, really to highlight the potential health risks and death from misuse and abuse. So I want to just highlight those and thank the committee for your time and attention to this critical issue. Thank you.
Thank you, Dr. Lee. While you're here on Zoom, are any questions from members of the committee for Dr. Lee? Not seeing any. You're welcome to stay on if you like as well. We also have signed up Catherine O'Meara. Come on forward, ma'am. And if you could similarly please keep your testimony succinct with regard to the underlying bill, and then if you have anything specific to comment about the penalty provisions that brought it to the Judiciary Committee.
Okay.
I did hear your testimony in Commerce and appreciate it, and we're glad that you're here to join us today as well to tell us your personal story. Just going to ask you to keep it focused.
All right, I'll do my best. I prepared it, differently, so I don't know if it suits what you're getting at.
I understand, and I'm sorry if you prepared a lengthier presentation, but we have a very long agenda. We're going to be here at least until 5 o'clock today.
Yeah,
so we're trying to keep our testimony focused on the provisions relating to the Judiciary Committee.
Okay, well, it's just a 1 minute long.
Please, go ahead.
Okay. Good morning, Mr. Chair Latz and members of the Chair Committee. My name is Katie O'Mara. I'm the mom of Tommy Byers, my only child. On November 1st, 2022, Tommy's life was stolen by difluoroethane, the poison in computer duster. My world stopped. My heart is forever broken. In a span of 3 weeks, Tommy's free will was gone. Tommy was no longer making decisions for himself. The psychoactive properties of the poison had taken over. Tommy wasn't my Tommy any longer. We must get huffing out in the open. It's out there, it's real, it's being abused, in some cases right under our roof. DFE must be exposed for the deadly poison it is. My son was an accomplished professional man, charismatic and deeply committed to his large group of colleagues, dear friends, family, and simply adored and cherished by his dad and me. I can't save Tommy now, but restricting this poison, we can save others. We must pass this bill. Thank you kindly. Okay.
Thank you, Ms. O'Mara, for sharing your deeply personal story. I'm in the chair now, so I can indicate we're sorry for your loss, of course. And,
Thank you.
so, members, we do have the bill before us now, and so we'll entertain any conversation or discussion relating to the provisions before the committee. Are there
Mr.
any
Chair.
such discussions?
Senator
Mann, go ahead.
Question for you. I do have an A7 amendment. This is the amendment that came after conversations with yourself and with Senator Howe and with the Household and Commercial Products Association. It does have more to do with the commerce side of it, and I'm happy to introduce it to that committee, but it is here before us. If you want to take it up to date, totally up to you.
What is your expectation where this bill is going to go from here?
Back to commerce.
Then we'll let Commerce deal with their
Perfect.
commerce-related amendment. All right. I'm also going to call the committee's attention to the correspondence that is in the packet and the letters that are there. Any discussion from members of the committee relating to the penalty provisions in the bill? Not seeing any. All right, then Senator Pappas moves that Senate File 3972 be recommended to pass and be re-referred to the Senate Committee on Commerce. All those in favor say aye. Aye. Opposed? Motion prevails. All right, thank you, Senator Mann. Okay, we're now going to take up Senator Mitchell's bills. We have two of them. Senator Mitchell, you can tell us which one you'd like to hear first.
Thank you, Mr. Chair. I will go in the order that was on the agenda, which would be Senate File 4204, please.
All right, Senate File 4204 is before the committee. Members, this comes to us from Health and Human Services. There is an A2 amendment, but it's not an author's amendment. So let's hear a brief description of the bill. And maybe I should ask counsel, the bill is only 2 pages. Is all of it before the committee here? Okay. The entire 2 pages of the bill are within our jurisdiction. So Senator Mitchell, go ahead and tell us about your bill.
Thank you, Mr. Chair and members of the committee. This comes to us as a request from the different ombuds offices, and it would add, it is here because it would add data for some of those offices. Those offices that are listed, which would be the ombudsman person for American Indian families, family child care providers, families, and foster youth, they do advocacy. So if someone thinks the process isn't working correctly or they need advocacy on a certain level, these are the offices that would help do that interface, and there's a lot of interface with DHS. They would be
asking these people to advocate for them, and yet these particular offices don't have access to the system. So then what they have to do is go and ask, maybe the social service office or the appropriate office with the information to give them that information, which could take weeks, even months. It creates a burden on both agencies. And also, they could be asking literally the agency that they might be about to investigate for the data that they need to do that. So this would just add in their ability to have read-only access to the information for their clients. The amendment is mostly a technical amendment. It renumbers sections and kind of corrects some internal references. And you should all have packets, or in your packet, letters from the different offices. Again, these are other governmental agencies, and similarly situated agencies do have access to this sort of data. I would also like to add DHS has a very antiquated computer system. Sometimes even the people putting the data in there have trouble getting the data back out in a meaningful way. So we are not sure that the Ombudsman's offices would currently even be able to access a lot of this data once we hopefully pass this bill. But we're separately putting money toward an entire new computer system. So this would at least set the framework, if the access still isn't available now because of computer issues, to have that done in a mindful way when the new computer system is launched.
Senator Mitchell, the proposed amendment deletes Section 2 of the bill, as well as some technical renumbering. That's what we have in front of us. Is that your intent?
Yes, sir.
Senator Limmer.
Mr. Chair, and pardon me for the interruption, Senator Mitchell. We do not have a copy of the bill before us. We didn't have a copy of the previous bill before us. I was hoping maybe the staff could bring us Senator Mitchell's bill so we could follow along.
Senator Limmer, there were a couple of bill packets that were distributed, and this was as a set, so it should be included. What you have, if you don't, we'll get you another copy. If anyone else doesn't have it, we'll get you a copy as well. All right, do all members have a copy of the bill before them at this time? Okay, we can proceed then. Is there any discussion about the Senate File 4204 and the proposed A2 amendment? I'm not seeing any. Senator Westland moves adoption of the A2 amendment. All those in favor say aye. 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 Opposed? Motion prevails. The amendment is adopted. Any discussion further on Senate File 4204 as amended? All right, Senator Mitchell, where does your bill go from here?
Mr. Chair, we are requesting it is laid over.
All right, then Senate File 4204 as amended is laid over for possible inclusion in the Omnibus Judiciary Policy Bill.
Thank you.
All right, and don't go anywhere because we have your next bill up. Senate File 4132, open meeting law. Does every member have a copy of that bill? Just want to make sure that we've got it all distributed properly now. You're good? Okay.
I do not have one, Mr. Chair.
You don't have it either? We can ask staff to go ahead and get copies of this to folks. I have a copy, but apparently others don't. Actually, I have a copy of the council's narrative. I don't seem to have a copy of the bill itself. Why don't we take a pause while staff distribute copies of the bill to us? While we're getting copies, members, you have 30 seconds to eat lunch. Go ahead.
Mr. Chair, assuming everyone is very, very well behaved today, I did bring homemade cheesecake. I will bring it and put it in the back here for everyone.
For members and staff only.
For members and staff. I did not bring enough for everyone.
So everyone in the audience, you're just going to have to drool while we eat our cheesecake. Watch out, we'll come back here with a sugar high. That's not going to be pretty. Do members have copies of the bill now? All right. Senator Mitchell. This deals with open meeting law, so maybe I should just ask real quickly, what's within our jurisdiction? Ms. Primo?
Mr. Chair and members, it's all of the bill except for Section 4, because the bill deals with some attorney-client privilege issues as well as a fine of civil penalty.
All right. Thank you, Ms. Primo. Senator Mitchell, to your bill.
Thank you, Mr. Chair and committee members. So this actually came out of an incident in my community where I will say I feel like open meeting law was pretty brazenly broken. And so just looking at how to handle that in my community in general, and then looking at the laws and how people could handle that, first, we found out that some of these laws and penalties and everything else had not been updated literally in 30 years. So the fine of $300 was set back, in 1994. The ability to recoup some of your legal costs set back at that time, everything else. So one, and my House co-author was on a city council, he said that even in his time doing that job, he had heard that pretty much it was so hard for someone to bring forward one of these cases just for the potential of a $300 fine that a lot of people are advised that it's not really a big deal. And it should be a big deal. We should have open government. So part of this is just getting this up to what I would say modern day. Also, the death of the local newspapers used to do a lot of this, watching and monitoring and taking some of these cases. And now that those do not exist, we need to make sure there's an easy path for citizens to help take these forward themselves. So that is what some of the penalty changes are, and some of the greater recoupment of legal costs, so that when citizens have to take these cases, that it is an actual penalty that kind of means something. Then the other portion of this is the change to attorney-client privilege. That is specific to the loophole that I found in my community. And I would also like to just add, after our successful hearing in state and local government, we do now have bipartisan support with names that will be added on Monday that have already signed on. So what happened in my community is and this happens in all communities on all different topics, but it happened to be on the SRO issue. And the city wanted to have that conversation in private. So the school board didn't know that there was a consideration of pulling the SROs. The community members didn't know it. They literally posted on the meeting schedule, we are going to have a closed meeting. And as hard as some topics might be, you cannot, we do that all the time. You can't go to closed meeting just to talk about a topic that you would prefer not to have in front of the community. The school board had no idea this was going on. When that conversation happened, they said, well, you haven't talked to us about this. We'd like to be part of this, but because right now we can't support if you do that, the school board hadn't even had a chance to meet. They said, we're going to proceed with the closed door. The school board attorney literally called the city attorney and said, it is very strict to use attorney-client privilege. And what it has to be is there has to be an actual lawsuit, and you actually have to be discussing things like defense strategy, things of that nature, actually attorney stuff, or that a lawsuit has to be specifically threatened, and that's very clear in the case law. It can't just be that hypothetically, if we do these things, there might be a lawsuit. Despite the warning from an attorney that it would violate attorney-client privilege, the city proceeded, had it in private, not just to discuss that issue, but then they also went on and made a decision, which means, and you cannot have decisions in closed door, things like a vote. So that addition is saying that much like we do for contracts and any other form of closed door exception, that now even that portion would be recorded, but only released to the public in the cases where it was found that attorney-client privilege was improperly used. So that would be an in-camera review, usually following an advisory opinion from the state, and it would take a couple years to get to that process, and only released on one of two cases: if it was completely inappropriately used, or if a city or county continued on after the portion that should be closed and continued to meet in private to talk about other things, that portion would be released. Because what is happening is, even if it's now shown that it was inappropriately used, and you go back and say, we want the notes of what happened, we want the recording, we want all of these things, the data is literally gone. So those are the big changes to this, and we do have someone from Minkoji that is able to talk about the need for some of these things on a broader level, if the committee would care to hear from him.
Thank you. Your witness from Minkoji can come on forward, Mr. Ehlers. But while you're coming forward, what is your intent with regard to this bill? Does it you want it to go to the floor? Do you want us to lay it over for possible inclusion? What's your preference here?
Also laid over for possible inclusion, please.
Okay. And if I've got Brian Lake also signed up as a testifier, so if Mr. Lake, you want to come forward while we hear from Minkoji, that'd be great. Go ahead, identify yourself and present your testimony.
Okay, thank you, Mr. Chairman, Senators, Senator Mitchell. Matt Ealing with the Minnesota Coalition on Government Information. Very, very briefly, I know the committee has a packed agenda. This is a good bill. Our organization supports it. Over the years, we have heard from citizens who have run into compliance-related issues with the open meeting law. And Senator Mitchell has identified those and brought them forward to provide a solution to all the citizens of the state of Minnesota. So I can stand for questions on the particulars, but I won't take up your time otherwise than to say this is a good bill and we support it. Thank you very much.
Why don't you stay there in case there are questions. Mr. Lake, welcome to the committee.
Thank you, Mr. Chair. Brian Lake. I operate a solo law practice in Minneapolis. I represent the Minnesota State Bar Association, and I'm here today speaking on behalf of the public law section of the bar, which consists of attorneys who represent various public bodies throughout the state. And when I start, I just wanted to say that when I sent this particular bill for feedback to bar sections after it got introduced, before I'd even heard anything from anybody, Senator Mitchell proactively reached out to me to see if we had any concerns, and I really appreciated that, and I very much appreciated her openness to discussing this issue. We've had some good conversations about it. I hope we continue to have good conversations about it. The public law section is particularly concerned about Section 2 of the bill, which requires mandatory recording of public body meetings that are closed for attorney-client privilege. And I think that goes right to the heart of that privilege, which is a very, very old concept. There's evidence of it existing perhaps in ancient Rome, but clear evidence that it's been around since at least the 16th century. It is a foundational aspect of our American legal system. And the reason it is so important is it gives the client a sense of security and protection, knowing that their discussions are private and confidential and not going to be used against them. The reason that is so critical is because an attorney needs full candor and transparency from their clients in order to give them their best advice and strategies. I know I personally have been in situations with clients, and Mr. Chair, you and the other attorneys on the committee have probably been in situations where clients didn't give you the full story about something. Perhaps it was something they were embarrassed about, and then that issue came to light, and you said, well, geez, now we got to completely change our strategy here. So it's very, very important that clients feel comfortable being fully candid about the issues that they're facing, and we are very concerned that the recording provision will have a chilling effect on the clients being fully transparent with their attorneys and with the advice that the attorneys give, because there's always the potential that recording, even if it's not used as considered under this bill, could easily be leaked either intentionally or unintentionally and get into the wrong hands. So I think a couple more things, Mr. Chair, quickly. I believe there's a letter from the League of Minnesota Cities and members' packets expressing similar concerns. And then I would note as well that attorneys who advise public bodies are duty-bound to tell them how to comply with the law, and those attorneys are also held to the rules of professional conduct. And I have been asked if that really means anything, if they're subject to potential discipline. Mr. Chair, I can tell you, having served 3 years on the 4th Judicial District Ethics Committee, every complaint about a lawyer, no matter how frivolous it might seem, is thoroughly and seriously investigated. With that, I would just reiterate my appreciation for Senator Mitchell and the conversations that we've had. I am hopeful that we can find an alternative solution that satisfies her concerns and the issues that she's trying to deal with, while also not giving major heartburn to attorneys who represent public bodies. Thank you.
If you two would stay there, let me first ask if there's anyone in the room that has any questions, or I rather would like to come forward and testify on this bill. Okay, I'm not seeing anything. I've got a couple of questions, if I may. I would assume that in this case, the local municipality that Senator Mitchell was most concerned about the conduct of, there could have been a complaint brought against the attorney that advised the municipality it was okay to go behind closed doors to have the conversation and to take action. Do you know if any such complaint has been made?
Not to my knowledge. I will say that even after an advisory opinion came down from the Minnesota Department of Administration, and pretty much every attorney around said this shouldn't have happened. The city's position is still to support that lawyer in their decision, and there's been public statements saying we just disagree, it's advisory, and there has been no commitment to changing practices.
And Senator Mitchell, do you know if there's been any litigation to challenge the application of the open meeting law here?
In the particular case in my community,
Yes.
No, nothing has gotten to that point to my knowledge, but the only way this law could apply is if someone went all the way into litigation, which is of course very expensive, and it would only be, anything would be released. To me, this is a bad actor law. So this would only be released if it went all the way to a judge who looked at the information and said, wow, this was really abused, and released on that level. So for the average people that I think are doing the right thing, and this is part of the conversation we had, because right now, when you go back retroactively, the community still wants to know there was a vote taken. Who voted what? Who said what on an important issue in the community? And literally, there is no data. There isn't even an email that's been turned over or anything. There is no data about what happened, and you can't recreate data in the past. So if there is this exception, that this loophole that bad actors have found, there's no way to fix it going backwards. And we haven't figured out a better way than this. I tried to put as many guardrails in as I could.
Senator Mitchell, are you aware of any other circumstances in which there's some kind of requirement that attorney-client meetings be recorded?
There is a lot of precedent in terms of the in-camera review portions of different sort of data that would go forward. And I would say, I would analogize it somewhat, I know it's different, but contract negotiations in the state of Minnesota, which has a lot of attorney aspects to it, are also currently recorded with some of the same safeguards. They don't necessarily have to be released unless certain criteria are met.
Senator Mitchell, are those contract negotiations, are they attorney-client meetings that are subject to the privilege?
Do you know off the top of your head?
Under the open meeting law?
Yes.
Mr. Ealing?
Senator,
Under any law, are the attorney-client privileged meetings?
So there are other provisions that are in the open meeting law that allow the recording of closed portions of meetings, such as labor negotiation contracts. So if there, for instance, was an attorney-client discussion that happened and was on the recording, and it was a legitimate attorney-client discussion, that would be exempt from any kind of disclosure under the open meeting law or otherwise.
Okay. But if there's a meeting that is an attorney-client meeting specifically, are you aware of any provision in state law that requires that such a meeting be recorded?
It's not to say that there is not one. I'm not aware of one, but I would draw analogies, Mr. Chair, if you wish, to the Data Practices Act and the Federal Freedom of Information Act. There are many, many instances, and I've been involved as a plaintiff in litigation where we've got into these kind of instances where documents that contain attorney-client information are subject to disputes over whether or not they actually contain such information, or are they subject to disclosure under the Data Practices Act or under FOIA. So in those situations, both FOIA and the Data Practices Act have an in-camera review component, so a judge can make an independent determination about whether or not data that contains alleged attorney-client conversations or advice actually falls within the scope of the privilege, or whether it should be turned over. Now, requiring a recording in the open meeting law context gives a judge the ability to make that independent determination. If there's no recording available, then they really don't have a basis other than to depose people who were there and ask them. So the recording provides that kind of base level evidence that they can review.
But Mr. Ealing, a deposition and asking people who participate in the meeting, that is a normal process within litigation to try to figure out what happened, isn't it?
That is correct.
Are there any penalties established should such a recording be leaked?
The recording would be government data under the Data Practices Act, and to the extent that it actually contained exempt information such as attorney-client privilege, it's protected from disclosure, and there are penalties available in the Data Practices Act. If such privileged data or private data is leaked, then the parties who are aggrieved by that leak could seek damages or other kinds of action under the Data Practices Act.
Okay. So I've got another question, if I may. On Section 3, it identifies a personal liability fine. So we're talking about, to use Senator Mitchell's example, any person, presumably here on the City Council, staff, lawyers, who violate the open meeting law would be subject to being personally liable out of their own personal finances for a civil penalty in an amount under current law up to $300, right? And the proposal is to increase that to $1,000, right?
Yes, Mr. Chair. This was $300 set 30 years ago, so this is to get it more in line with modern And also, we went through what other states have, and this is more in line with what other states have. Ours was exceptionally low at $300.
So what if the city council members are engaging in that meeting on advice of their counsel that it was lawful to go into a closed meeting? If a judge in an in-camera review later determines that the meeting was not properly closed, then those individual city council members and staff who participated in the meeting could be liable for a personal financial obligation up to $1,000 on a first violation?
Mr. Chair, so to me, it would be, in this case, there was a vote to go into the closed meeting. It would be the electeds who, and the word intentional is in here. So I would think that if you really just got bad advice that you had no other way to know should have been wrong, that the intent would go to the person who should have known the law and skirted it. In this, I also think, I mean, we sit in government. To me, I think anyone's mind should be triggered when you're going closed meeting, that's a very narrow exception, and that you shouldn't be voting in it. So I think we need to also, in that intent, not have people kind of put in a position where they are being willfully ignorant about a pretty basic, I mean, when I heard what had happened, it didn't sound right on its face, that there was no actual lawsuit and attorney-client privilege was used to have a meeting on a topic. I mean, it was very clear there was no lawsuit, and that attorney-client privilege was used to close it and then also to continue on to a vote.
Okay, so I'm just trying to drill down here to who might be liable and under what circumstances. So if the municipal attorney, the city's attorney says, we need to have a meeting on this, I believe this would be an attorney-client privilege meeting for whatever reason, lawsuit pending, no lawsuit pending. My legal advice to you, city council, is this would be an attorney-client privilege meeting. And the council follows that advice and votes to go into a closed meeting. But they voted to go into a closed meeting, which is later determined to have been improperly closed. That's an intentional vote. Would that be considered a violation of the open meeting law? And if so, would they then be subject to this penalty?
Go ahead.
Mr. Ely.
Mr. Chairman, I would argue that the intentionality goes towards bad actions. Reliance upon council's legal advice, if you're a city council member and you believe you're getting proper legal advice, I don't believe that would raise to the level of intentionality. And the intentionality is what triggers both the civil penalty and the removal provision later in the bill.
Okay, and then $1,000 for a first violation and $1,200 for any subsequent violation. So the next section of the bill relating to forfeiture of office specifies separate intentional violations of this chapter. But if you had someone committed a violation a year ago and then there's another violation now, there's another violation in 2 months, it could go on forever, theoretically, right? Unless and until the forfeiture provision is triggered and takes effect. Am I understanding that correctly?
Yes, Mr. Chair.
And maybe I should ask the clarification from any one of you who knows the answer. When it says any person, would that include staff, or is that just an elected official that's subject to the open meeting law? Mr. Ealing, do you know?
Mr. Chairman, in the case law that I've seen, the person is normally referring to the member of the public body. Now, could that be clarified there? Certainly. But the case law that I've seen shows that the person is the elected official who serves in the public body.
Does Priya know? Ms. Primo.
Mr. Chair and members, person is not defined in Chapter 13D, but the idea is it's generally the elected official, although that could certainly be clarified, but I don't see anything in the chapter that specifies that.
And then, I mean, I'll tell you up front, I've got an issue with laying a $1,000 fine on an elected official for doing something like this, if it gets to the point where it's determined they're liable. But then you've got an attorney's fee provision on page 4 of the bill, which says unlimited. It strikes the limit and says reasonable attorney's fees could be awarded to the prevailing plaintiff, right? So who would pay those? If it got to the point of awarding attorney's fees, who would pay those fees? Senator Mitchell?
Mr. Chair, it would typically be either the city or the defendants, depending on how it was named in the lawsuit. So typically in these lawsuits, it's a combination of the city being named and then with individual defendants. So I believe it would be up to the judge to determine how those were allocated in that case. But again, the process for this is typically someone gets an advisory opinion from the state. And then with that advisory opinion, if it's positive, then goes into the lawsuit process, which right now is almost impossible for someone to do. Because of the cap and the cost, there are very few attorneys that will take these cases because a citizen would have to come entirely out of pocket to sue whatever the entity was, to not have probably most of those costs recouped, to have the person who intentionally violated the law and violated open meeting law to get a $300 fine at the end of the day. And right now, it is just not happening.
So Senator Mitchell, a citizen or a citizen group could do that as well, right? I mean, cities get sued all the time by groups of neighbors that band together, all pitch in to come up with enough fees to hire an attorney and pay their attorney whatever it costs to bring a lawsuit. So it could be a citizen group if enough people felt aggrieved. But theoretically, then, you could have an individual mayor or a city council member subject to an unlimited but reasonable attorney's fees and costs for a single violation under the way you've got this drafted. Am I understanding that correctly? Mr. Ealing?
Mr. Chairman, the open meeting law handles penalties in a couple of different ways. So the $1,000 or $1,200 penalty, as the bill suggests, would be levied against the individual member of a governing body. In the case of attorney's fees, there's existing language in the attorney's fees section here. If you look at subdivision 4C, the public body then may essentially pay for the attorney's fees that are levied by the judge in the litigation. So it wouldn't fall to necessarily the individual.
Not necessarily, but it might.
It's possible. There's always room for clarification there. But the tradition has been, as I understand, that the public body will pay the attorney's fees in those cases.
All right. And then, Mr. Ealing, on the next paragraph, B, you do cap the attorney's fees that may be awarded to a defendant. So why is that capped? Meaning someone who is frivolously and without merit sued and incurs $20,000 in attorney's fees to defend that frivolous and meritless claim, only allowed under your proposal to recoup $10,000 of their out-of-pocket expenses. Mr. Ealing.
Mr. Chairman, under the American rule, where we assign attorney's fees based on legislative action, and those are put in place to forward different public policy purposes, that's why the legislature has discretion to say there's going to be unlimited attorney's fees, or we're going to limit attorney's fees.
I'm not disputing the legislature's discretion. I'm trying to get the policy purpose here.
And Mr. Chairman, the $10,000 cap comes out of an experience that we had heard about from an individual who had sued a public body, retired individual of limited means, and then the judge in that case found that his lawsuit was without merit, and then assigned $13,000, which is the current cap for attorney's fees, against him from all of the members of that public body. So he was saddled with $70,000 something worth of attorney's fees. And this is somebody that just misunderstood the law. I think those kinds of folks should not be penalized if they are misunderstanding how to apply the law as a citizen against a public body. And I think those kinds of claims, if they are without merit, are generally going to be kicked out of the legal process pretty early. So that's our suggestion there, Mr. Chairman.
So, Mr. Ealing, if it was simple misunderstanding of the law, it wouldn't fit within the definition of frivolous. Frivolous would, I think, basically be an almost intentional disregard for what the law clearly says, yet they bring the suit anyway, and there's an and there, so it's not just a non-meritorious claim. It'd have to be a frivolous claim that apparently caused $70-some thousand worth of attorney's fees to be spent defending it. But, all right, well, as I'm analyzing this, I will just tell you candidly, I'm sympathetic to the situation, and I would probably support the provision in Section 1 relating to the attorney-client privilege, but I'm not certain I'm comfortable about recording it, and I'm not comfortable with the changes regarding the fine increases and the fee shifting. For me, I'm not comfortable with that, but I'm only one person here on the committee. Let's see if anyone else has any questions or comments. Senator Uma Verbaeten.
Thank you, Mr. Chair. I, too, have some concerns. Just want to ask a few questions. In Section 5, when Senator Mitchell, you referenced that, I'm sorry, not Section 5, Section 3 on personal liability, that those increases are modeled after some other states. Could you share what some of those numbers are from the other states? And also, do other states allow individuals to be personally liable?
Senator Mitchell.
Mr. Chair, Senator, I don't remember them all off the top of my head because this is something we worked on over the course of months, but a lot of the fees ranged from about $500 to $2,000, and there were a number of states that did have the tiering where if someone continued to do it, like the second fee was more as a deterrent, which is how we modeled that. I mean, I know it, unless you know the number off the top of your head, I must have looked at least a dozen different states and how they were doing this. And that's how it came up. And yes, because to get to this point, there has to be a vote by the public body to close the meeting. And so if they are making a choice to break the law based on their vote, that would be an individual decision as an elected.
Senator Uma Verbaeten.
Thank you, Mr. Chair. I think one of my concerns there, too, is just thinking about the different levels of elected office folks have. And I did receive a letter of opposition from my school district, Roseville area schools, on this. So I'm thinking about our school board members versus city council members, members of the legislature, and what that impact of those 1,000 to 1,200 violations would be, especially for folks who receive pretty little compensation for their service. That's something I would encourage you to continue to think about on this bill. But did you have a chance to look at the opposition from Roseville Area Schools and Superintendent Jenny Lake?
Senator Mitchell.
Thank you, Mr. Chair. Thank you for the question, Senator O'Mover-Baton. So I have 2 open meeting laws, and I did see an email from her this morning that was related to a different open meeting law bill that I had. I have not seen something in relation to this. That one has also a recording provision about open comments in meetings, but that provision is not in this bill.
Senator O'Mover-Baton. Any other questions or discussion from members of the committee? Senator Kreun.
Thank you, Mr. Chair, and I won't go over all the issues that you raised, although I was going to go into some of those areas. Certainly don't want to encourage abuses of open meeting laws, but I'm also very protective of the attorney-client privilege, and having been in closed sessions based on attorney-client privilege, that if there is a recording, the conversation is going to be different than if there's not a recording with elected officials. And it's not going to be as open and as frank and that's the purpose, in large part, of the attorney-client privilege. And, you know, another concerning part that's been touched on, I just wanted to elaborate on it, is about the vote itself, you know, breaking the law with the vote for a public official. But I've been in that situation, and a lot of times you don't know exactly what is the issue exactly is until you're in the closed session. You know it's for attorney-client purposes, but it's not like you've been extensively briefed beforehand, and you know when you're voting to go into closed session whether or not it's a legitimate attorney, going to be legitimately protected by the attorney-client privilege. And so in those situations, I think the elected officials are relying on the advice of their lawyer primarily when they're making those decisions. And even when you get into the meeting after you voted to go into the closed session, it's the lawyer's responsibility to keep your conversation within the guardrails to make sure you're not straying off to violate that privilege. And so throughout the process, I think the lawyer is the one that is kind of directing that. And so, you know, to me, I think the proper enforcement of this is through the professional responsibility of the lawyer and the disciplinary proceedings if the lawyer is abusing this open meetings provision. I don't think that we need to do this through a recording of the meeting and some of these penalties, and I won't get into some of these other issues that have already been touched. So I'll just move on and say I have the same concerns as the ones Senator Latz set forth. But one additional question I had is when you get to the lawsuit itself and the recording then would go to the judge for an in-camera review, what happens next? Is the court's determination dispositive of the entire lawsuit? Because normally when a judge is reviewing attorney-client privilege communications, it's in an evidentiary standpoint. It's whether or not it's admissible. But here, the way I'm reading it, that would be the end of the case. The judge would review it in camera, and if the judge thought there was a violation, it's over or not. Can you speak to that?
Senator Mitchell.
Yes, thank you for the question. First, you know, I'm a member of the bar too. I understand these considerations, and I think none of us want bad actors because it makes us all look bad when people are not following the law. I will say to one of your comments that the state law on and what our own Supreme Court has said on attorney-client privilege is very exceptionally narrow to go into this. So you have to have a lawsuit, or someone has to have specifically said, I'm about to sue you on this issue. So to a certain extent, I think for the elected to understand there is no actual lawsuit and to just follow along and go along with, okay, attorney-client privilege and start taking votes and doing other things. I mean, I think we should hold our electeds to like a certain minimum level of, you have to kind of sanity check what's going on and not just roll along with bad advice, because I think all of us have gotten bad advice at some point in time, and we have a little personal responsibility to know when that is happening. To the part about the judge, what would happen is if it got to the judge and they found it was a breach in the law, that there really wasn't a case, and it got to that level, which again might take a year or two to get to that level, then they could release any portion of that recording that was not attorney-client privilege. So in the case of the example I gave, where there really wasn't for any of it, but let's say there had been a portion that was, but then they went on when they should have reopened the meeting and started doing other things and other business, then the judge, for example, could release that portion that should have always been public and should have always been something that the public had an access to. Because at the end of the day, this is why we have these laws, is because the public has elected us and they have a right to know how we're making our decisions, who's voting for what conversation is being held. And so you should not continue to do other business while claiming attorney-client privilege.
Senator Kreun.
Thank you, Mr. Chair. So, yeah, the elected official might know about an existing lawsuit, but they certainly might not know about a threatened lawsuit. In fact, that's normally when you go into closed session, oftentimes it's somebody's threatened a lawsuit, and that elected official doesn't know that until they get into the closed session. They don't know the details. They don't know about the threatened lawsuit. So when you're sitting there voting to go into closed session, you're relying on the advice of your counsel at that point primarily. Now, sure, there could be egregious examples where but I would say the overwhelming cases, you're going to be relying on the advice of your lawyer, and that it's a legitimate basis to go into private or closed session for attorney-client privilege purposes. However, I understand that a judge could make public portions of the recording that, based on the in-camera review, that maybe are not attorney-client privileged, but that doesn't end the case. There still needs to be an adjudication to get to the penalty provisions. And so my question was, if a judge determines that it wasn't attorney-client privilege, or that a portion of it wasn't attorney-client privilege, is that dispositive of the damages, or is it just then those portions are released and made public and then there's a trial? Because to me, like, the process isn't set forth on what happens there.
Mr. Ewing.
Mr. Chairman, Senator Kreun, in the context of open meeting law litigation, the question before the court is, was there an intentional violation of the open meeting law? So the intentional violation would be the decision to go into closed session for attorney-client privilege when that was not really the case. To go into closed session to cover up the discussion of information and discussion that should have been public. So if the judge reviews the recording in camera and discovers that it's not attorney-client discussion that's going on, it's about how we're going to handle, putting in the municipal baseball field and what we're going to spend on it, that should be in the open session, and that will be an intentional violation. Once the intentional violation is established, then the individual penalties can apply, and the attorney's fees, et cetera, can apply. So the disclosure of the recording would come about through a lawsuit brought under the Minnesota Government Data Practices Act. So in this context of the open meeting law, the judge would purely be looking at the recording as evidence of whether a violation occurred.
Senator Kreun.
Mr. Chair, I'll just leave it at that. I have other questions about it, but in the interest of time, I'll move on.
Senator Seeberger.
Thank you, Mr. Chair. I understand the intent of this bill. My concerns lie with subdivision 4, the cost attorney's fees, et cetera, and specifically making changes to specify in subdivision A that they can be awarded to a prevailing plaintiff instead of any party, removing that cap, and then imposing a cap on the defendant, and awarding costs and fees only if it's frivolous and without merit. I don't like these kinds of attorney fee shifting provisions. I think the American rules should be at play here. And I have a particular problem with taking a cap away from a prevailing plaintiff when the defendant to be paying that is it comes from tax dollars. You're talking about a city, you're talking about an entity or something else that's generally funded with tax dollars. So I don't normally agree to those kinds of things. I can't agree to it in this case. It's my understanding this bill is being laid over anyway. And those are my comments. Thank you, Mr. Chair.
Senator Carlson.
Thank you, Mr. Chair. I have a couple questions just on the procedure here. Whenever there is a closed session, does that meeting require an attorney to be present?
Mr. Chair. Senator Carlson, yes, because that is, in theory, if you're using this properly, you should be getting your attorney's advice on things such as what is going to be our strategy for the case. You know, what might our filings be? What is some of the evidence that you need to tell me about and whatever happened? So yes, the attorney should be part of all of this.
Thank you, Senator. Mr. Chair.
Senator Carlson. Mr. Ealing, did you have?
No, I think Mr. Chairman, I think I misunderstood the scope of Senator Carlson's question. I thought he was asking about any closed session, but if it's specific to attorney-client privilege, the answer is yes, the attorney would need to be present.
Yeah, I heard the question more broadly as well, and there are other statutory provisions that allow closed meetings that are not related to attorney-client privilege.
Yes.
Mr. Chair, human resource discussions maybe
if I misunderstood the question, certain contract negotiations, certain private employee-related items, things of that nature, every other type is recorded.
Okay, and I guess.
Senator Carlson.
Yeah, thank you, Mr. Chair. So what that means is that what we were talking about here is being a privileged attorney-client is not the only description of an instance where you can have a closed-door session. So there are some others that also fit that.
Yes.
And,
Senator Mitchell.
Sorry.
Yeah, thank you, Mr.
Senator
Chair. And Senator Seeberger, are you looking at those particular meetings as being closed session, or let's say, falling under that requirement of recording them when some things may be decided there that are not necessarily described as privileged attorney-client information on contracts or in any of those that do fall under the legitimate attorney-client information subjects that are being covered in a closed-door meeting?
Senator Mitchell.
Thank you for the question. So to me, this would get us in line with those because in every other situation, we do record them and we preserve them and they are kept privileged unless they are released under certain circumstances.
Thank you, Mr. Chair.
Not seeing any further questions, Senate File 4132 will be laid over for possible inclusion in an omnibus judicial policy bill. Thank you, Senator Mitchell.
Thank you.
Members, we're going to take a 5 to 10 minute recess so members can use the facilities, grab their lunches, And when we reconvene, we will take up the gun violence prevention portions of the agenda. Members, if you have extra paper that you'd like to remove from your possession right now, if you get up, leave it on your chair, and staff will pick up the paper and recycle it. All right, we are in recess until 12:50 or thereabouts.